number 21 of today's hearings. Council for her respondent. Apart from favor.
Item 21, password.
Lordship, never may take after 2 weeks.
Let it get passed over first. You see,
Much all.
and the request also. Yes.
Daily list for admission matching one.
The last occasion during the course of the hearing, when I was referring to the inquiry report, in the inquiry report, your lordship's attention was drawn to the
Some records required to be produced. What the records?
This is having only 5 minutes. One party there, 5 minutes.
Then we take it up in the second half. No, take it up. The second.
Item number 2.
Let's see in the last debate. Where
Who's for the state?
I think my not
Who's for the state?
is not written by anyone. Let's take okay. Yes.
Where is that report that you are challenging? It's 26-4. Page number.
Please, 44. Findings of the subdivisional level.
44.
44. These are findings of the subdivisional level committee, which was brought as per the direction of the Honorable Court.
And what is your ground for challenging this?
The main issue is that I am according to the respondent number 5.
You are not a permanent resident.
No.
Then how do you want to dispel this controversy?
It is not page 78 and 79. Is the total list where my name is enlisted at serial number 180. It is first one is type copy and ignore one.
What is these private respondents?
Yes, not it is page 76. In this total list, categorically 76.
Yes.
The type copy of the total list in which is categorically mentioned by the authority of the election commission that he belongs to number 1 Gov Society.
And you belong to?
I belong to number 2 Society.
And the Anganwadi center is situated?
Number 2 Society.
Where is Where do you find it?
So it is, can you see the page 42? It is a report of the officer concerned that with reference to the subject article, I have honor to inform you that so and so, I visited number to proceeding missing. From this letter, it is expected that the Anganwadi is very situated at number to proceeding.
No, let us see the advertisement.
Well, the advertisement is a page 80. 180.
Where is it mentioned?
It is a common notice for any Anganwadi address.
No. You see the employment notice, it begins with Anganwadi worker, Anganwadi helper in each Anganwadi center cited below. So perhaps there is a enclosure here. Where is it?
Is not coming in the presentation.
But where is where is the original?
Originally, page 21, followed গাঁও পঞ্চায়েতৰ অন্তৰ্গত কেন্দ্ৰস্থান দিয়া হ'ল। I mean, annex in the whole of center.
So where is it?
It's not annex here.
Not the next.
Suppose. Followed গাঁও পঞ্চায়েতৰ অন্তৰ্গত
The location of
Perhaps there is some enclosure here which must have been left out. The Gaon Panchayats are mentioned are as per the advertisement.
The center's name.
Centers names are mentioned here. Where is the earlier order of the court?
this page 20.
In terms of this earlier order, you were a party. You were a party before this court.
I was not part. As per the direction of Mr. Report, committee was formed. No notice was issued to me. I also not decided.
Where is the direction to be heard?
Lordship, you kindly come to the page 32.
32.
Sorry, that's second paragraph of the committees to be constituted by the commissioner and secretary as appropriate shall be so constituted as expeditiously as possible, but not less than so and so. Of 2010. Upon such constitution of the committees, same shall be notified. The petitioners shall approach the same committees with their individual. I was not petitioner at that time. Individual and unauthenticated petitions, which will be treated as their representations. As suggested by the learned counsel appearing for both of official and private respondents, they may also submit their authenticated copies of the affidavits, which have been filed in some of the petitions. Such authentications may be made by the parties themselves or their learned counsel. In case of any doubt regarding authenticity, the committee will be at liberty to get the same verified product, the learned state counsel. Upon submission of the aforesaid documents, the committee, as per its own modality, find out the truth and or otherwise of the grievance made in the petitions.
There was no direction to be heard.
As per the direction of this honorable court, it was they need to form before 31st January of 2010, but it was formed after a couple of years, means 4 or 5 years. And no notice was issued to me. Lordship, there is judgment also of this honorable court regarding the necessary justice.
We are not doubting your submission with regard to natural justice. We are trying to understand what was the direction of this court in the earlier round of litigation in respect of how the hearing is to be conducted by the committee.
Hearing was not, I will, that's why I'm saying also no notice was, no.
Notice will not be issued. Notice was not issued because perhaps there was no direction to issue notice.
Yeah.
It was to be notified, committee was to be notified. And you were also not a petitioner that time. Were you a petitioner?
No, I was respondent.
You were appointed,
I'm starting in the.
you were appointed. So the penultimate paragraph will apply to you. It shall be open for the selected and appointed candidates. Towards the end of the page. Five lines from the bottom. Page number 32, 5 lines from the bottom. It will be open.
Yes, it was formed, not as per the direction of the court. After 4 or 5 years they formed it. So it was, I was not aware about the formation of the committee. So I could not find the affidavits or any representations regarding my submission.
Mr. Soronius Klein, were you a petitioner at the time earlier?
I challenge matter because non-resident was belong to matter.
So you approached the committee after this order.
Minor. According to committee, I have report them. The secretary that I will find out the possible second. Are you reviewing the rules?
Was there any hearing conducted? Personal hearing?
I am not sure, but possibly minor yes, appear to the committee.
Yes, government.
Lordship, so far, Lordship, the earlier direction, Lordship, from this honorable court, Lordship, the CGPO sent a letter to me that still now, still that Lordship is not found the inquiry, the inquiry file also. This is where.
What do you mean, inquiry file not received means?
It means, they stated that, I have not provided any details of the inquiry report of the specific instruction as the method in which the post was advertised, which is, he was not, aware of this inquiry at time, but, so far, which, from the director,
Hmm.
I can get, I may get the instruction also. But so far, looks it, this is the inquiry also, that, on the basis of that inquiry report also, on the basis of the earlier direction of the office honorable court lordship, the inquiry was conducted lordship, and the report was submitted lordship. And the report is clear that, the findings of the report is clear. Therefore,
No, the question is, how did the report arrive at that conclusion? On what basis? Because the petitioner says there was no notice, they were not heard.
lordship, the inquiry lordship, that inquiry was done by the committee lordship. And he members be heard lordship, but at the same time lordship, the inquiry, in the
Will
inquiry.
come to page number 44.
Yes, lordship, in the inquiry report itself, stated the reasonings, the way the.
Correct, so come to the observation. There is a remark that the respondent means the petitioner here is not a permanent resident.
The respondent does not belong to the, ST community, whereas, the 100.
No, below that.
Yes, after verification, any scrutiny of the.
No, second.
Scrutiny of related documents and government certificate and environmental supervisor certificate is found that the petitioner are objection are true, the respondent is not a permanent resident within the, say, Anganwadi center, this clear.
So it is clear, but then he objects on the basis of a voters list
Lordship.
to show.
Anganwadi center, lordship.
uh,
So Anganwadi center is created after a survey, lordship. Survey was conducted, house of.
So where is this Anganwadi center located?
It is, the Anganwadi center. Do you know Kashwati missing, lordship? Do you know Kashwati missing?
From where do you say that?
Yes, it is name of the Anganwadi center, lordship, it is Duinam Kashwati missing. But it is column number 4, lordship, in the.
Now you have to correlate this with the advertisement. So come to the advertisement. The advertisement says the list of centers under Gaon Panchayat are given below. But it is not available.
The Anganwadi center, the area of the Anganwadi center is depend upon the survey, lordship.
Very well, but this is a case of appointment of Anganwadi helpers and workers pursuant to an advertisement. So the advertisement must specify
Yes.
under which area that Anganwadi center is located.
In the advertisement, you should.
Which is why on the last occasion, government was asked to obtain instructions.
No, I think they have some another phase. Because this is
Which
the-
is why we want the records from the government.
Yes, Lord. Yes, whether the area was defined or not. In the
Area, how it was defined, how the inquiry was conducted, you are not bringing it in your affidavit. Probably you have not even filed your affidavit.
Lord.
You have not filed your affidavit.
This is so far, lordship, From the director office, I will contract with the directors of taking all these things, Lordship, but so far from the CDPO, Lordship, I am not getting any instruction.
What instructions did you seek from the CDPO?
Lordship, CDPO. The CDPO stated that
No, what instructions did you want?
it was regarding whether that area, which is claimed by the inquiry was conducted on.
See, come to page 44, this inquiry was conducted by a committee
Yes, Lordship.
to be constituted or which was constituted in terms of the orders of the court. Committee comprised of a chairman and 2 members.
Yes, Lordship.
So this committee, on the basis in, at least in respect of this particular Anganwadi center, conducted an inquiry. If you come to the remarks and observation, you will find that after verification of related documents, etc., so it is expected that these references to these documents should be available in the file. If they have actually conducted an inquiry.
Yes.
So you have to get that file. So that will not be available with the CDPO.
Yes, it is not available. According to him, Lordship, it is not available.
No, not again according to him, according to us also, it should not be available. Why have you asked for the file from the CDPO? You should get it from the directorate. We have given sufficient opportunities.
As for the order of the committee is created by that particular person.
Let us find out who has done it.
That's why I
So,
just.
Lordship, I am not I am not able to verify that the signature of the chairman, who is the chairman at the time, Lordship. And then
You don't have to, it will be available in the records of the office. This was an opportunity given earlier on 27/6 to your colleague.
I will try, Lordship.
No, you are trying doesn't help. The matter is before the court,
Yes.
we have to pass an order. Or we try ourselves, we call the director along with the files. That will be quicker. Let him be present in court on Friday.
Please provide me a.
Please go through the earlier orders we have passed.
I will.
When can you get it?
Lordship, next week, Lordship.
Next week or the other day, sounds. Okay. Fourteen. 14. Oh, All right, heard the councils for the party. Mr. Hazarika, we have to go through the records
Your Lordship.
because otherwise it involves a factual dispute. Heard the councils for the parties. In spite of earlier orders being passed by this court, the complete instructions necessary to resolve the dispute before this court has not been made available to the learned government advocate. So the dispute in the present petition pertains to the question relating to the residence of the petitioner vis-a-vis the private respondent in the area in which the Anganwadi center is stated to be situated, namely number 2, Society missing down in the district of Himalayan. So both the petitioner and the private respondent claim to be residents of the same village, same area, and therefore claim their right to be appointed to the Anganwadi center. While questioning the claim of the other. So under such circumstances, as the dispute arises out, as it is a factual dispute, which needs it is necessary to verify from the relevant records available in the department. So accordingly, another opportunity is granted to the government advocate, Mr. J.K. Goswami, who will obtain the relevant records pertaining to the inquiry stated to have been made in respect of the number 2 Society missing down Anganwadi center by the committee stated to be constituted in terms of the order dated 10/12/2009 passed in WBC 5209 of 2017. So the learned government advocate will obtain the relevant records relating to the state inquiry stated to have been made. So these records will be produced before the court on the next stage case. So if the directions, if the instructions as directed are cannot be produced before the court, this court may contemplate issuing orders for personal appearance of the responsible officers of the department.
There are also things in the third last week also, because the record may be in the office of the deputy commissioner.
Where is the deputy commissioner? Where?
Yes, the deputy commissioner, deputy also.
Hemaji. So who is supposed to get it from Hemaji?
Lordship, first, the director may pursue, Lordship, director will pursue, Lordship.
Forwarded to the commissioner, secretary, government of some.
Mr. Goswami, we are in a stage where a craft is scheduled to land in the moon today. And you are worried about Guwahati and Hemaji on getting records? Are you contemplating that the office of director will send somebody walking to Hemaji to get the records? Then 14th, no further. Matter is listed on 14th September.
Lordship.
Yes,
Reference 25, some of reference in the agreement.
concern file, we are asking for the concern file.
Regarding the, center is to be reserved or not, that is a question.
All these will be available.
Item number 3,
May I please your lordship? Lordship, at the onset, I humbly prayed for legal correction in the order passed by the honorable court in the last week. Lordship, it has been stated that it is reflected in the order that the housing quarter C was given to me. Lordship, the thing is this that except housing quarter, no other C is given. So I can correct it.
All right, we'll correct it. Yes,
So apart from that, my submission is this lordship that even after 30 years of giving service to Coal India lordship, I'm still hanging in the thin air lordship. Lordship, in that case, lordship, my prayer for regulation may be considered lordship.
are you getting the minimum scale?
I'm getting 650 rupees per day lordship. It comes to 17,000.
Now this is 36.
Now, there was some agreement between the workers' union and Coal India that you will regularize the services.
Yes, lordship, at page 32 lordship. The terms of settlement is there, options. 2015 lordship.
That was a legal consideration. Unfortunately, Coal India, like other public undertaking, is not allowed to regulate.
What was the earlier terms of reference before the tribunal?
Earlier terms lordship. Stated that is monthly.
That was termination of service.
Termination of service lordship. The account was reappointed. Re-engaged.
But why do you want to keep somebody on daily wage for 30 years?
The policy of the government not to regulate.
That's okay, then you release him. Don't keep drivers, don't keep people. Why are you keeping people on a daily wage basis for 30 years?
You will already disengage because again,
Whatever, you went up to the Supreme Court rejected, so you are bound to accept this order.
not regulating.
Not regularizing, but you are bound to get him back into service.
And that is doing, and is within only other facility, besides. Besides the daily wage of certain living. Is getting quota. And medical facility.
Now, subsequently, there was another. There was some conciliation proceeding
Yes, your honor.
pursuant to his application.
It is
Even the constitution, it was agreed that they will try to consider about the regulation apart from the welfare schemes to be provided to them. Since that was not respected, therefore we have approached this very good.
Has it been sent to the, has it been rejected? Is it available here somewhere?
It declares that it's going to be- Page 38, last page, the letter from Police. The last paragraph. And we will have to read option. It is also pertinent to mention that the nature of the job of Sri Vibhav Chandra Das is a scheduled worker and his request for declaration to permanent worker is not possible at this stage. He was agreed upon during the conciliation meeting and he was also informed accordingly.
So you have agreed to that meeting?
No, Lordship is 32, page number 33, saying Lordship, the terms and condition of the terms of settlement. Lordship, no way it is written that I have agreed. They had said that they will send a proposal to their higher authority to consider my case. But see, Lordship, that page 32, it is agreed that since local management is not competent authority for taking any decision on the evaluation of the service of Sri Vibhav Das, a proposal will be initiated immediately and his service can only be regularized subject to the approval of the competent authority. So they are saying that it was not authorized.
Now, what orders do you want from the court?
At this stage, we are not sure. I understand the difficulty of the course and the management that the regulation may not be possible. Not sure, at least some different welfare schemes may be given to me, not sure. Because I am due to retire in within 2-3 years.
What schemes do you want? What welfare schemes do you want?
This is medical facilities that not sure like other. I have to look after my children, my old aged mother is also staying with me, not sure. And everything I have to bear from my own pocket. I'm getting a salary of around 17,000 much. It will be difficult for me to surprise much. The management also is little bit sympathetic towards me. And I consider my case. And also,
Page 44, para 12. That's affidavit in opposition, para 12.
yes, Lordship, they have stated that they are providing medical and free facility. But Lordship,
They are giving you company quarter, medical,
I agree, Lordship. I am.
OPD facility, water supply, electricity, school. They have given you.
This for children, my children, Lordship,
Huh?
they are studying in Assam Medium School. And in their campus, they have this UKV. Since I cannot afford to send them in UKV. And because there's a system in the government there, that if they're wards of coal employees, then the fees is less. But if they are going there as a private.
That they will provide. They have already stated that they are providing you.
Lordship, my children are now, because of this, Lordship, my children are studying in Assam Medium School, Lordship. Adarsh Vidyalaya. Don't know how they have said that they are having school facilities much like when children are staying.
What school facilities are being given?
Lord, here.
There is a statement here that you are providing school facilities. School facilities will mean that within the campus, there is some school you are, he says his children are not going there.
Not going there with choice.
No, he says he can't afford it because he is not an employee technically.
No, not in that. He not said.
That's what he just submitted.
Permission is nothing on that.
For employees of Coal India, there is a facility in the DKV that infrastructure is less. But,
So why are your children not going there?
because I cannot afford it, Lordship. I can, because I am sending them to Assam Medium School.
Your affidavit is also slightly vague because you are not giving the particulars of what you have given, water facility, medical OPD facility, what facility? What happens to some medical treatment if he has to take? Are these included in the OPD facilities? Perhaps not.
We have our own hospital.
But you say OPD,
Yes, sir. We think are not giving there, but they get only.
what is the minimum wages that he is required to get now?
You're getting 736 per year.
So what remains to be decided now? They're making a statement.
Lordship, intelligence, lordship, I have to find the defender where I can become the court change. Facility, and medical facilities, they're on my own expenses, I'm going to this common medical. And then other. I think this is a long pending matter, therefore I was lacking to finally join that. Now, since they are claiming, even from the basic facilities also.
Who will decide in case of any grievances not being resorted to in terms of your statements made in amendments made in the affidavit? Who is the authority? General manager. Okay. So we are closing this writ petition. Heard. Anything else you want to submit?
No, no, this is it.
Heard, learned councils and parties.
Lot of citations you wrote, I'm not referring to them.
Sorry,
Lot of citations are not referring to them. Regarding
you can refer to such.
this 25, 30 years also, they're not.
There are other citations also, which of course is not referring.
What part is their lordship?
That if you are extracting service, then you must have a scheme. If you need his services or people like his services,
That's the reason you're getting.
Again, lordship is yours. What the union says lordship, under 226 lordship can. Competent authority, lordship can direct to issue some methods to. So it's not, fixing it. Fixing it now.
you make up your mind what you want to press because we are closing the writ petition now.
I will rely on this case, 2019 566 773. Union of India versus Union of India and others versus All India Trade Union Congress and others. Lordship, in paragraph number 14 and 15, especially 15 lordship, that will be out. The High Court failed to see that it is not the function of the courts to frame any scheme, but it is the sole prerogative of the government to do it. All that the High Court, in exercise of its extraordinary power under Article 226 of the Constitution, can do is to direct the government to consider for framing of appropriate schemes having regard to the facts and circumstances of any case which this court did what the labor union do, but not beyond it. It is only in an exceptional case where the court consider it proper to issue appropriate mandatory directions, it may do so, but not otherwise. In this case, lordship, the court India will be the appropriate for the lordship.
But that is their submission that it is because of the scheme that you are getting all these facilities. Which means the scheme is in place.
And we are tagging up your lordship.
Heard learned counsels for the parties. This writ petition has been filed by the petitioner, who is employed as a driver
Yeah, okay.
within bracket casual worker under the respondent number 3. since 1994. Stop. The organization who is the employer of the petitioner is the Coal India. Namely, the respondent number 1. Stop. The petitioner was engaged as a casual worker as a driver within bracket casual work on 22/09/1994 at a consolidated pay of 1,500 per month. Stop. Subsequently, he was removed from service by the management on 25/5/1997 on a verbal order without issuing any formal order of dismissal, without giving any opportunity of imparting. The petitioner approached the regional, who is respondent 5, approached the regional labor commissioner and who was pleased to hold a conciliation proceedings. Stop. However, the state conciliation proceedings failed and the matter was referred to the industrial tribunal as a reference case, registered as reference case number 14/C/1999. The tribunal, by award dated 10/08/2000, held the determination of the workman from service was illegal and it needs to be re-engaged with immediate effect. And directed the management to issue necessary orders for immediate re-engagement of the petitioner. So this order, this award of the court was assailed by the management of this high court by the petition number 5553 of 2001. Stop. By judgment and order dated 6/2/2008, the petition was dismissed, against which the management preferred an appeal, being it appeal number 141 of 2008. Stop. The appeal also came to be dismissed and the Learned Single Judge's order was upheld. Stop. The matter traveled to the apex court, and as the management preferred an preferred appeal, being SLP within bracket C number 18078 of 2008. Stop. The state SLP also came to be dismissed, as also the review petition number 947 of 2008, filed by the management against the order of dismissal by the apex court, also came to be dismissed. So thereafter, the petitioner, by communication dated 22/12/2008, was directed to a report for duty at Margherita, which is the headquarters of Northeast Coalfields, Margherita. Stop. Subsequently, by order dated 8/1/2009, the petitioner was posted at ENN department. Stop. Petitioner, it is submitted. It is submitted by the learned counsel for the petitioner that the petitioner has been re-engaged as a casual driver on lump sum emolument of ₹2,000 per month only. And he has been discharging his duty without break/interruption of continuous service. So, in spite of representation being filed before the competent authority, the management not accepted the prayers of the petitioner seeking regularization. Stop. The counsel to the petitioner submits that while other similarly situated workers, casual workers working as drivers came to be regularized. However, case of the petitioner was never considered for regularization. Stop. The case of the petitioner was taken up by the Assam Coal Mine Workers Union, LIDO. And the conciliation proceeding was further held in the office of the Regional Labour Commissioner Central, Dibrugarh, which was attended by the representative of the Coal India, from the Workers Union and the petitioner. So. During the conciliation proceedings, an agreement was arrived at. Whereby where is that agreement? Page 31.
32. Page 32.
Not agreement, only the memorandum of settlement was arrived at. Whereby it was agreed that the area B of the petitioner with retrospective effect from 1/4/2015 would be released within 30 days from the date of settlement. And further, a proposal for regularization of the service was to be initiated for approval before the competent authority. Stop. General Counsel for the petitioner submits that in spite of the memorandum of settlement arrived at between the parties, the management neglected to implement their share of responsibility in respect of the terms of settlement arrived at between the parties. Stop. It is submitted that this settlement is pursuant to the conciliation proceedings arrived at, initiated by the Regional Labour Commission within brackets Central, in terms of the provisions of the Industrial Disputes Act, with the rules of so and so, rules dated so and so. General Counsel for the petitioner submits that he is still continuing his services as a casual worker on a daily wage of what is the amount you are getting
17,000.
daily?
Daily 650.
650 rupees per day, which comes to about 17,000 rupees per month. Stop. Uh, The counsel for the petitioner submits that till date, no action has been taken by the respondent management authorities in respect of these representations as well as the terms of settlement arrived by and between the parties as per the settlement date dated so and so. Stop. Under such circumstances, the petitioner has approached this court, praying for appropriate direction or order. Stop. The counsel to the petitioner has referred and relied upon the judgment of the apex court and the All India Trade Union Congress and others reported in so and so. Stop. It is submitted that on the given set of facts and circumstances, the writ court is not denuded of its powers to issue specific directions to the respondents to frame a scheme for regularization of workers like the petition. It is submitted that in an exceptional cases, the court may also consider it proper to issue appropriate mandatory directions. So, Mr. Ramzan Ahmed, Leonard City Council, assisted by Mr. Dr. submits that the counter affidavit of the whole India has already been filed. He vehemently disputes the submissions made by the Learned Council for the petition. According to Mr. Ahmed, the petitioner's case cannot be regularized as the same has not been accepted, as the proposal sent has not been accepted by the competent authorities of the Coal India Limited stock. The Coal India is a government company. Therefore, the government rules, regulations, as well as the guidelines are required to be implemented in respect of the employment of workers engaged by the Coal India stock. Referring to para 12 of the affidavits filed by Coal India, Mr. Ahmed submits that the Coal India has provided basic amenities like company water, medical OPD facilities, water supply, electricity, school facilities for his children, for the children of the petition. Stop. As such, there is no malafide intention of the Coal India in not regularizing the services of the petition. So the petitioner was engaged as a casual worker and is continuing in his services as casual worker. Stop. He is today being given a daily wage of ₹736
From April.
from April 23. April 2023. Stop. All other facilities which are ordinarily available to workers of the Coal India have been given to the petitioners. Petition stop. As such, until any such scheme is framed by the government of India in respect of Coal India or other public sector undertakings. The claim of the petitioner for regularization cannot be accepted. Stop. There are Mr. Mehdi, learned counsel for the petitioner, in rejoinder submits that he's been, that the petitioner has been granted company quarters, but other facilities. But what is your submission regarding the other facilities? You said company quarter is given.
Company quarter is given to my lordship,
Ah.
but medical facility is not given to me. And regarding the facilities of providing school amenities to my children, this is also I am objecting lordship, I'm not getting any.
He objects to the submissions made that company facilities are being offered to the petitioner stopped. He submits that except for the company quarters. Water supply is also you're not getting. It must be.
Yes, water supply. is
Except for company water and water supply, other facilities are not been extended to him. He therefore submits that in the event the court does not issue any directions to the respondents for regularizing the services of the petitioner, or the relief claim may be molded by directing the authorities to at least provide the basic amenities as mentioned in para 12 of the affidavit. And the respondents go to the petition. So there are learned counsels for the parties have been heard. Meetings on report have been carefully perused. Judgments cited at the bar which will be noted. So the clear case of the petitioner, he is a claim for regularization. For in the respondent organization, namely Northeast Coalfield. Do you say NEC or Coal India Limited? He is working under what? NEC. NEC, which is under Coal India Limited. Stop. While there is no dispute that the petitioner was engaged as a casual worker and has been continuing as such on a fixed pay. However, the claim for regularization will have to be considered in view of the law laid down by the apex court. Stop. The consistent view of the apex court, respect of claims for regularization, are that ordinarily it is for the employer of the government to frame a particular scheme depending on the requirements for seeking for conferring regularization on such workers who are working as well or daily wage laborers. So during the present proceedings, no such scheme has been brought to the notice of the board by councils representing other parties. So the proposal stated to have been forwarded to the authorities concerned by the Coal India Limited has been held to be rejected by the Coal India So, however, the rejection order is not here. Is it available?
What is it?
Page number?
30,
Huh?
page number 30 is a letter, Lordship.
It's a communication, but
That can be considered as a rejection letter. Or the-
stop. Referring to the terms of settlement of the agreement arrived at. Terms of settlement arrived at between the parties concerned. It is seen that the terms, the memorandum of settlement dated 2nd December 2015. In the memorandum of settlement arrived at by and between the parties on 2nd December 2015. The following terms of settlement were agreed upon. Page 32, terms of settlement 1, 2, 3, 4, 5. Para. The Coal India Limited does not dispute the terms of settlement arrived at by and between the parties as per the memorandum of settlement dated 2nd December 2015. Stop. While it is to be accepted that ordinarily a report will not issue directions for regularization or to the employer to frame a scheme for regularization. However, the fact remains that these terms of settlement agreed by and between parties reflect that the proposal was to be initiated immediately pursuant to the terms of settlement for regularization of the services of the petitioner, subject to the approval of the competent authority. So, the pleadings available before this court does not reflect any specific orders rejecting the proposal sent by the competent authority. Stop. Save and accept a communication dated 7/10/2015, which is enclosed as Annexure 6, page 30 of the written petition, which was communicated by the Regional Labour Commissioner Central Union. Oh, sorry. Where is that communication? Sorry. Rejection of your proposal?
Lordship, page 38, Lordship.
38. Sorry. Annexure P11, page 38. Issued by the nodal officer Grievance with this cell, Northeastern Goldfields. This is addressed to whom? 38.
Purnavati Das, Vidyanagar.
Who is she? Your wife? Mother?
Yes, Lordship. Yes, Lordship.
Whereby the case of the petitioner was the case of the petitioner for regularization to a permanent worker was declined. So in Jagjit Singh versus Union of India reported in so and so, the Apex Court has categorically held, Apex Court has held elaborately that in respect of the rights of casual or temporary workers. Apex Court held that they're entitled to the minimum of pay scale and all other benefits which may be available to the regular workers. Stop. The stand of the Coal India in the present proceedings are that the petitioner has been provided with all the facilities which are ordinarily available to a permanent worker. Are there any other facilities available to the permanent worker
I'm not aware.
which are ordinarily available to the permanent worker? Stop. Which, however, has been disputed by the counsel for the petitioner, except for issuance of company quota with water supply. Stop. Under such circumstances, this court is of the view that in view of, in the face of the law laid down by the apex court in so and so versus so and so, that the casual workers are entitled to minimum of pay scale. The Coal India will continue to offer the minimum of pay scale to the petitioner for the services rendered by him. As a casual worker, besides other facilities like company quarter, medical facilities, water supply, electricity, as well as school/educational facilities for his children, as may be offered to other regular workers. Stop. The minimum of pay scale is to be paid to the petitioner in terms of the provisions of the Minimum Wages Act 1948, as well as the other government instructions which are issued from time to time. Stop. That apart, the court is hopeful that the Coal India will take up the grievances of the petitioner as well as other casual temporary workers seeking regularization into regularization as permanent workers, considering the several years of services rendered to the organization. So the authorities in Coal India will consider implementation of any such scheme within the framework of the policies and the guidelines issued by the government of India from time to time. So if any such policies are framed, then cases of the petitioner, case of the petitioner along with other similarly situated workers be given adequate consideration. Stop. These steps required to be taken by the Coal India are expected to be taken in right earnest and on an urgent basis, considering the claims made by the petition. In terms of the adopted petition stands disposed of, no order is proposed.
If you are going to, if he has any, taking a approach, we will take.
Liberty is also granted to the petitioner to approach the Coal India authorities to ventilate any further advances. And yeah, upon such an event, the Coal India will sympathetically consider the cases of the petitioner and pass appropriate orders.
Congratulations.
Item number 4.
Government and secretaries take time, right, activity, but they.
Yes,
This is your lordship, I am appearing on behalf of witness for your lordship. Instruction awaiting your lordship, because we're able to obtain instruction your lordship because extra party has not been served upon us.
Earlier it was start by a long back. In the past order, they have stated before this court that they have received any instruction.
you could have requested the council that you wanted a copy.
Yes, your lordship.
Have you requested him? Instead of saying that you could not get it because there was no instruction, you are a government council.
In the last order. Particularly long back.
What is it that you're challenging?
And there is what happened by that. The list was provided for regulation of particular law. The first name. This my lord, the name of the.
There is no regularization now.
No. It's pursuant to order of the interpreter court.
The retemplet court did not direct
It is
regularization.
not submit the list of worker. And submitted the list of officers, submitted the list of worker.
Hmm.
The first list, well, the name of the petitioner will included. But subsequent, in the next list, well, the name of the petitioner will excluded, and name of the two brother-in-laws of the IFS, well, was very. Getting by.
Yeah, make sure, see your lordship, that is on page number 182. Where your lordship, it was mentioned that 181 page. Your
Then
lordship.
you were not working.
No, I was working, madam. At present, I am not working, because my name is not provided, madam.
Your lordship,
In the first list, madam.
it's not easy, your lordship, last portion, your lordship.
When you receive your wages, since when were you not working? When was your name deleted from the list?
In 1999.
19.
Right.
So when you work, you receive your wages.
Right.
So do you receive any documents to substantiate that you have received your wages for so and so month?
My name is there in the list,
I'm asking you something else.
madam.
When you receive the wages, are you required to sign?
When I received the wages,
Kindly see page 180,
madam.
the last line,
It's madam.
page 180.
One, first time, 180. 180, last.
You have been, the authorities consider you have held that you voluntarily left your engagement.
Wrong, man. That's bad.
No, I know that is your contention, that is wrong, but how do you want to dispute this?
No, I submitted. It is in the petition, madam, grounds why I get in, madam.
No, your grounds are not sufficient for this court to decide.
Madam,
This is a factual dispute.
madam.
So therefore, I am asking you, do you have any documents to substantiate this contention? That in 2018, you were still working.
Then I have to take a step. Okay.
This is the core of the issue. According to them, you were not there, so you had voluntarily left, so your names were excluded.
But then I have to take a step. Because I have to decide.
And your lordship,
One name.
Yes,
in page 181, there is also one allegation that the report reveals that both the incumbents were negligent in duty and disobeyed their superior authority.
where is that report? Where is that report?
That I will obtain, your lordship.
How are you so confident that you will obtain, in spite of your request? You have not been furnished with instructions.
I will find my.
From where? From where? Which office?
Your lordship, please.
Hard learned counsel for the parties. MS P. Deka, Das,
Yes.
P. Das.
On behalf of Naya,
On behalf of Mr.
P. Naya.
P. Nayak submits, instructions are awaited. There are from Annexure K. Page 180. Which is the order impugned in the writ petition. It is seen that there is a finding by the Principal Secretary, Bodoland Territorial Council, that the petitioners had left their engagement voluntarily during the month of March 2018, and that they were negligent in their duty and disobeyed their superior authorities. Stop. This finding has been arrived at by the BTC authorities on the basis of a report. The Learned Standing Council for the BTC will obtain instructions in the matter, and the relevant records reflecting the report on the basis of which this finding has been arrived at. Stop. Mr. Maheshwari, Learned Counsel for the petitioner, submits that he would also like to complete his instructions in respect of these contentious debate. Matter be listed after
Yeah, there's actively
3 weeks time.
19 or 21 September.
19 or 21.
Council day, we have visit. Very quickly, but the matter is discussed other.
All right, 21 September.
Deep units.
And please serve extra copies.
I'll be.
You can serve them, you can serve them in a soft copy also if they want.
Item number 5.
Maybe. Now, if you not are appointed under the Assam Public Service, appointed in 1989. But they are appointed irregularly, my lord, they are supposed to be appointed regular appointment. And my lord,
Lordship will kindly pass over the letter for timing, lordship. Rahul Gandhi, you will be appearing, lordship.
All right, second half.
another thing.
After 1 week, after 1 week. At the request of counsel for the petition.
Item number 6.
Yes,
Matter pertains to my lord, termination of the petition on this matter on material ground. My lord. And there is an order, under order of this honorable court, my lord. After going all aspects and my lord, this honorable court passed direction.
what about the pleadings?
Your lordship order.
Have you filed?
Yes, complete, my lord. Well, may I have a lordship order with 23-2. What are you?
Yes.
23-2. 23.
Mr. Mehdi, affidavit is fine.
Previous file. What happened, we have to this order of password to not good.
Hmm.
Just couple order, last minute is. You obviously found that the order that 8 February 2023.
8 September.
8 February, 8 to 22. First one, this is Mr. Suman.
Hmm.
And dear Miller is ordered on 13/3/2020.
Hmm.
Well, after now, I have replaced the inspector Miller, and after that Miller is on particular date Miller, the question was the termination was not set, termination order. So Miller, this it was my comparison was like this Miller, to amend the rate. So for this, as because of the there is no silence in the termination of the registration Miller, it was Miller from either amended registration or find the budget in the.
Where is it mentioned in the
It
order?
does not mention that. It does not. So my learned press time. It is one prayer of the from Candid Kadi, learned council for the made with the concern of the scheme, the learned CGC acting personnel. This method is directed to be posted again after 2 weeks. As so for enable the petition of the council to obtain updated instruction. Instruction. Please go.
Yes.
Well, here is not silent.
My lord, kindly may refer the earlier order of the Honorable Court, page number 81. Already after going.
What are your prayers in the first place?
Where is my page 14 now? Seriously, should not be issued a sitting as an equal the order of 14/9/2020, issued by Commander Science. Next matter, seriously, should not be issued sitting as a proceeding DERB, forwarded dated March 30/7/2022. Therefore, amendments should not be issued directly responding to reinstate a petitioner in any post as specified standing under the so. These are words, but
So there is no challenge to the termination order.
Well, this petition, commission is there. This petition, second round of petition, is in continuation of the earlier order. My lord, may I submit, my lord, the earlier order, the direction may be my lord referred. It is important, my lord.
Page number?
Page number, my lord, 81.
Yes.
The direction is, my lord, very specific direction, my lord.
85.
Yes, my lord. 85, my lord. 84, my lord, married, my lord. 2 paragraph married, my lord.
Yes.
84, my lord. Because after going through the pleadings and the documents relied by them, my lord, paragraph number 5, married, my lord.
84.
84, paragraph number 5.
5. Yes.
The respondents filed evidence opposition opposing the claim of the petitioner claim for reinstatement to the service. In the process, the court by order is one to directed the land council of the respondents to seek instruction as to whether the petitioners can be accommodated in some other occasion such as one from other. The land council for the respondents for time to seek instruction. In pursuant to the direction of this court stated about the respondents filed additional affidavit along with the epidemic 2 documents among others are filed. One is letter dated sworn to of the statutory commandant what is attached to the central government council, and the other is standing order dated sworn to along with amended order sworn to the release date of the letter dated sworn to is extracted. Now the DIG by signal number sworn to has integrated to this officer the instruction with regard to each affiliation of 4 personnel available in Sanction order 411. My lord, standing order, I think, my lord. Standing order 411 provides that for those who are disabled due to injury sustained in action against terrorists, anti-social elements, insurgents, nationalites, while maintaining law and order, internal security, and undergoing training. The petitioner comes under undergoing training. He sustained injuries during undergoing training. For any other bona fide duty, the department should make all efforts to take care of them without compromising with overall efficiency of the competent force. It is also provided that after the injured person has been given full medical treatment, If the medical officer in that is of the opinion that there are no sign or indication of the improvement and the individual is not fit for normal active duty, the case the individual should be referred to the departmental rehabilitation board by the unique office situation concerned. Thereafter, the personnel who is eligible to appear before the departmental rehabilitation board and the board will subject the person concerned to physical examination with a view to determine his physical mental capability.
Any appeal filed against this order? Any appeal against this order?
No. No,
Where is that order before the standing committee?
Minus, before the order man, they will not have 8 minus.
We have read it, we have read it.
Yes,
Yes, take us to the,
yes. Direction matter for personal as part minus standing order minus. Page number 87 is the impugn order number
87.
87. And 87 minus the text is there and minus relevant page number 90 minus. Before the text are page number 90, paragraph number 13 is the minus findings. After completing the quarantine period, DRB was assembled on 37/28 so now their recommendations. Numbers of Mustaq Ahmed has not completed his basic training at present. After having attained injuries in most of his knee, he will not be able to complete his basic training in future, nor he is able to take any strenuous work in highly active and mobile force.
Where is that standing order?
Yes, yes, I have annexed here. I have annexed here, page number 49. 49. Specifically mentioned by the provision is there, page number 49 and exactly 1. Is their document, they have submitted those number 4 number, page number 49, my lord, rehabilitation of force personnel in suppression of earlier orders and instruction included standing order and the particular following order, laid down rehabilitation of disabled persons. Number 2, the department has 3 categories of disabled persons. Petitioner comes to a my lord, undergoing training. Then from my lord, the department will take all efforts to take care of the disabled persons without compromising with overall efficiency. For therefore, a sick injured person should be given full medical treatment at unit level in civil hospitals. The responsibility is to ensure that sick injured person get full medical treatment including the medical officer in charge of base hospitals and on the head of the unit. Full medical treatment will also include treatment of admissible artificial and joint. So after the sick injured person has received full medical treatment, and medical injuries of the opinion that there are no sign of indication of improvement and that the individual is not fit to normal activity. In the case of the individual should be referred to departmental rehabilitation board. The person eligible will appear before the board, which will consist of this is the board my lord. Next my lord, 6, this board will subject the person concerned to physical examination with a view to determine his physical mental capability. So for physical examination, this honorable court has referred the petitioner to the DRB method, the rehabilitation board method. Number 7, after physical examination of the person and assessment of his
What was the injury suffered?
my lord, first he got into the left knee, my lord. Some ligament and medical terms there, my lord. He sustained injuries. And my lord, after treatment for few months, he has been given the my lord fitness certificate.
What is the injury suffered now?
Now my lord, both knees, my lord.
So he cannot stand up,
Yes, my lord, he can stand, my lord. He appeared before the board in the Chhattisgarh, my lord.
and he cannot walk.
He walked, my lord. He can walk.
Ah.
But the board's, my lord, opinion is.
Then why is it not taken in terms of this?
Well, this man only this because they insert this matter. Those are insert. These matter the basic training. Definitively insert the training and basic training.
Then you go and challenge the order of the court.
Here.
No, Mr. Mehdi, Mr. Mehdi, please, this. The direction of the court is very clear,
Yes,
specific.
Paragraph 8 Miller.
Yes. Yes.
From this documents filed by respondent on the respondent on the direction of this court, it can be concluded there is a scheme of grievance from a person injured during training. Therefore, if the petition is disposed with the direction, the component of the petition under whom the petition is worked. Respondent 5. to refer the case of the petitioner to the Departmental Revision Board at the earliest, but not later than 3 months from the date of receipt of certificate copy of the order, for critical examination. For the critical examination of the petitioner case to determine his physical and mental capability, attitude and job requirement, etc. Here the to recommend, the right to examine manner. We examine manner, yes,
Mr. Medi,
and
Mr. Medi,
yes,
this is an order of the court. My limited understanding of the language is that it is not to consider. It is to consider with the purpose of giving him an appointment under the standing orders.
minor.
You are under your rights to go and appeal or file a review against this order. You have chosen not to do so.
Another thing is made clear the termination of the still stand matter.
It shall not come in, it shall not come as a bar.
It was in earlier on 13th in 23, this question was put to my lord.
Mr. Medi, you are representing the central government.
Yes,
So kindly do it with a great deal of responsibility.
I understand. Madam.
So this order which has been passed here, this order is very candid, very categorical here. That this order of dismissal shall not come as a way. You did not go in appeal, you did not file a review.
But here, madam, to examine us.
Examine for what purpose? Examine for what purpose? What is the purpose of examination? Is it because the authorities in CRPF have no other business but to examine? Therefore, is that the reason why the court has granted you the direction? The examination is for the purpose to see whether he can be re-employed in terms of your standing order.
Yes, madam. Yes, madam. That madam, standing order is those who are in service. Madam.
No, kindly see para 8,
Yes,
first line.
yes, madam. Yes, this can be compared the first.
There is a scheme for rehabilitating persons injured during training.
Yes, madam. Training is the type of training, madam. One is minor, the three.
Your interpretation of para 8 is not acceptable for the simple reason that this is not a memorandum. This is an order of the court.
Understand, madam. So we examine.
If you do not comply with, we are compelled to issue contempt notices.
That is the dear madam, but here when they direct to examine, madam, we examine, madam, and so madam.
Examine for what purpose? You have to examine in terms of the directions issued by the court. You said he's not mentally, physically.
Yes, capable or not, madam.
Why are you saying physically not capable?
Another thing is.
Why are you saying he's not physically capable?
Another thing is the board of, madam, board was not made party here, madam.
Who is the person responsible for giving you instructions here? Let us call him. You are not being able to assist the court. Who is giving you instructions?
Then I on the 30 of this month, I will take no proper instruction.
No. We have given you enough instructions. You are trying to interpret an order of the court.
I placed, madam.
You are trying to interpret an order of the court, Mr. Medi.
I placed this said instruction before the court on last occasion, my lord. And 2 weeks time was granted by them, my lord. It was made on 13th.
Maybe you go and appeal against my order. If you want, you can go and appeal against our order. I don't see this order any room for interpretation. This order is attained finality. You have not gone in appeal, you have not filed a review.
Yes, that is true, madam.
Then
But as per this honorable court order, madam, I placed this instruction.
it is not reflected in the court's order.
Yes, so much there to time, madam.
It is not reflected in the court's order.
Madam,
You show us in which court's order it is reflected.
I am reading another order, madam. On
Yes.
8 to 2023. Heard Mr. Yanjit Kadil, council for request also heard Mr. S. K. Minutes, European correspondent who seeks posting for this method again on 23 to 2023 as fixed item. So enable him to obtain instruction as to whether some relief can be granted to the prisoner even at this stage. They are allowed. The seriously may consider as the whether prisoner can be accommodated in some other post where his disability may not come in the way of discharge of his duty or else if suitable compensation can be paid to him. Since the injury was the prisoner was during the basic training undergone done by him under the supervision of the authority. Copy of this order so this method on 23 to 2023.
How is this order at variance with the directions of the earlier single judge's orders?
No, well, this means, the instruction was, directed to the instruction regarding the earlier order.
Who is directed to take instructions?
Well, you are not to come down on the, gonna change the rate, madam. On.
8/2/2023 order you have read.
Yes, it was,
Who was directed to take instructions?
and 23 to 2023.
Come to 8/2/2023 first.
Yes, sir. 8 to 23.
Who was directed to take instructions?
My order date 22 or 23 to.
No, come to 8/2/23.
Yes, madam.
Please read the order again.
Heard Mr. M. The Curry Learned Council from for the Federation, also heard Mr. S. Kim. The Learned from CDC appearing for the respondent. Who seeks posting the method again on 23 to 2023 as fixed item to enable him to obtain instruction as to whether some relief can be granted to the petitioner at this stage. Prayer allowed. The learned council may consider as to whether petitioner can be accommodated in some other course.
No, not learned council.
Learned CDC may consider.
Now, who is the CGC?
I'm myself was it.
So, who was supposed to get instruction?
Yes, this one, but they have to next order, then next day, you have to make on next day. This matter is next day on 13/3/2023.
23 to my lord.
Next date is 23/2. Then comes 27/2. Then comes 10/3.
Yes, sir.
13/3 is the last order.
13/3, last order, madam.
Yes.
Last order, madam, the learned students of learned council made with the consider the scheme is CC appearance this matter directed to be posted again on after 2 weeks. So that enable the petitioner's council to obtain updated instruction. Well, my friend.
What happens to the earlier orders where you were directed to obtain instructions?
Yes, I submitted my, because of.
So please submit, we want to hear your submissions.
Then one of this, on 30 of this month, I'm again, the never fix, I'll take up to the instruction. Yeah, I understand, it will be good. 13 March.
Your pleadings are there, what further instructions you require? Your pleadings are completed, you have filed your affidavit, you filed a reply, what further instructions do you require?
Yes, madam, it is up to you.
What instructions do you want?
Madam, so far, madam, there is, whether he can be accommodated or not. This one.
Yes, Mr. Kadir.
My lord, the lord, earlier order of reasonable court, already my lord has that my lord is entitled, my lord, is entitled for rehabilitation, my lord. There are documents for the support, my lord, the standing order, my lord.
What are you asking for?
My lord, as for standing order, my lord, reasonable court, my lord, may direct, my lord, for.
In the impugned order, it is mentioned that you are asking for compensation.
No, my lord, that is not right, my lord, because my lord, there is no mention that he is able for any other, my lord, subordinate, my lord, as for standing order. So my lord, for standing order, my lord, complying with standing order, he is entitled, my lord, for. He is taken from Kachar to my lord, Chhattisgarh, my lord, to attend the DRB, my lord, the government education board. In such a situation, my lord, they have.
We are giving you opportunity to obtain instructions, whether he can be accommodated. Is that what you are asking for?
Madam, another matter, I'm just, madam, his prayer person. This.
You wanted time till 30 for what purpose, Mr. Mehdi?
Madam, if this one good for whether he can be accommodated or not, that particular appointment.
Accommodated as what?
As per the this instance, the standing order.
Standing order.
And
All right,
another-
we'll give you an opportunity.
This prayer person only the setting aside his rejection of smile of his by the board of regulation board. This was that form order recommendation is silence. And another silence is the thereafter the authority pass an order of 14/9/2000 as per the regulation board. This is the matter it was passed, that order. So if this order to set aside, he will not be reinstated. Even because it required to set aside the order of Tamil somewhere.
Oh, give us some meaning to the directions of this court. in the earlier round of litigation at paragraph 8.
I understand, that is my dear, it is already dear.
Now, if it is there, then we need to rephrase it and implement, issue another direction. We'll issue directions for contempt for non-compliance of this order, willful and deliberate violation of this order. There is already a direction that this termination order will not come in his way. What is the meaning of that?
But this authority understand when the examining.
How the authority understands, you are expected to convey it to us, you are an officer of the court,
Yes, understand.
you are not employed under the authorities.
Yes, sir.
So your interpretation has to be as per the law.
Yes, sir. But here is a little, whatever he said as well, is paragraph 12, where deployment reason, he board.
We are giving you one last opportunity to obtain your instructions and thereafter we'll consider the matter.
Yes, sir. On 30.
Heard learned counsels for the parties at the request of Mr. S. K. Mehdi and at CPC. Matter stands adjourned to 30 August. Stop. This adjournment is granted at the request of the CGC to obtain instructions from the, what authority is this? CRPF. CRPF authorities. As to whether the petitioner can be accommodated in terms of the standing orders. What is the standing order number dated?
4/11, my lord.
4/11.
27, my lord, July 2011.
4/11 of 27 July 2011.
There is amendment also, my lord, dated 4/8.
Read with the amendments up to date. Depending on the instructions as may be forthcoming, on the next day fix, the appropriate orders will be passed in this court. List on 30.
Item number 7.
All right, we will be already.
Second half.
It is likely to be dismissed. Already I have got the information that the instruction has to be. All right.
Who is the counsel?
He has also told me.
All right. At the end of the list. Second half.
Items 8 and 9.
Yes, 8 and 9. Mr.
Looking for that, may respond.
Respondents. There's nobody for the petitioner. We'll pass it over till the second,
Next Monday, my.
next Monday. None appears list. Mr. Dole appears. Were you waiting outside? Yes.
In this case, also, we have linked to the final order. For in my of the fine inclusion to site which they have been imposed. There is an extra 1 page 24 laws. I want to submit one thing also. I have recorded in this case also.
What is the fine imposed? 5 days.
5 days finals.
And what is the ground you are challenging it?
One thing is that I have challenged the nature that has been denied to him.
Why?
Because one we have requested for some document, Lordship, which has been denied, Lordship.
Did you file your statements
Lordship, I have submitted, Lordship.
before you file an appeal also?
Lordship, and appeal and a revision petition I have given exposure.
Before the appellate and revisional authority, did you take up this ground of natural justice?
Lordship,
Where? Kindly point out.
and actually the petition has not been annexed here with Lordship.
Then inquiry officer appointed.
No, my lord, actually,
I have also paid for Lordship for a departmental inquiry, that has also been denied, Lordship. Without assigning any reason, Lordship, my
Conducted the inquiry.
my lord, actually, for a minor analysis, well, an inquiry is not required.
What is this CRDF?
CISF.
CISF.
1968 is.
CISF.
Rule 37, my lord.
Rule 37.
Rule 37. B. May differ. Holding an inquiry in the disciplinary authority so desires in the matter laid down in subsection 3 to 22 of Rule 36. And the Rule 36 is sort of minor penalty. Since it's a minor penalty only, that is why matter inquiry was not required.
Under Rule 36,
No, 37B matter.
37B.
That is required only for the minor penalty, that is Rule 36. For 37, that is not required.
So some inquiry is required.
That's how yes, but educate opportunity was given. Your lordship has taken my affidavit in the position.
Now, first, let us have a look at the position in the rules.
Yes, sir.
So you'll have to first inform the member in writing.
Yes,
Then there's some inquiry to be held.
yes.
Then
Only the departmental inquiry was not given, but an ample opportunity was given. Since it was a minor penalty, fine and equivalent to the 5 days pay only. That is the reason. And if it is a major penalty, yes, that is a mandatory problem.
what do you say?
I have
They are not Supreme Court judges.
So I have taken the stand of a government of India instruction, okay? That is, I have mentioned in paragraph of case 16 in paragraph 14 of my petition.
Page,
Case 16 of my petition and paragraph 14. Page 16.
Yes,
Here is the last paragraph. The order of Government of India Department of Personnel, CRPO in number dated 20 October 1985 is evidently stated that in case where the government servant request for holding a disciplinary inquiry, even in case of minor penalty, the disciplinary authority should apply its mind and form its opinion whether the inquiry is necessary or not. In case the disciplinary authority comes to the conclusion that an inquiry is not necessary, it should be recorded in writing indicating its reason instead of rejecting the request for holding the inquiry summarily.
Where is this notification? Is it enclosed?
No, I have not included those, but they have also not denied it. In their order, it can be reflected.
In what?
In their order also,
Ah.
reflected, they have not denied this notification. At paragraph 26. Page 26. They have not done anything without no application. Either is it not.
What are your charges?
Charge number 1, Lordship, that page number 24. Number so Sandeep Kumar so has committed an act of misconduct in that on 6/2018, he had applied for 13 days earned leave with effect from 7/8/2015 on the ground of relative dates. But the same was not sanctioned due to shortage of manpower, especially that of ASOS as well as high alert in the run-up to Independence Day 2018. And the same results were informed to him by the company commander and the unit commander. Instead of making the competent authority or exhausting the channels of the department to express his demand, he approved the local police visit demand on 7/8/2018 at about 17:30 hours, thereby bringing extraneous influence in departmental matters. Thus, he indulged in an act of indiscipline and disregard of orders of competent authority as well as tarnishing the image of the post. These are charge 1 Lordship, and charge 3 that Twinso has committed an act of misconduct in that when he was called for an explanation for directly applying online leave to Chief Commandant CISF headquarters, Guwahati, and calling him without even approaching the unit commander, he refused to receive the explanation letters from unit CHM. Thereby, he indulged in an act of disrespect, misconduct, and insubordination. The above act on part of doing so amount to gross misconduct, indiscipline, insubordination, and unbecoming to member of the discipline post like CIO and HR.
So some inquiry was conducted. This is a matter of record. So some inquiry was conducted. Now, how are you prejudiced by not holding a departmental inquiry or giving you any further? What documents you wanted?
I have mentioned in my application notice, certain documents are there also.
Which application? Which application?
Page 25 notice in the order. The final one, page 25.
25. Yes.
Here is notice. The start official in his representation has stated that he has submitted an application and requested the disciplinary authority to provide the additional documents and clarifications in connection with the above charge memorandum and the details are as under. 1. Whether there was any DDNG or article of charges has been made in control room of CISF in connection with the charge memorandum. If yes, provide English version copy of DDNG. Secondly, if there was any special report has been submitted by the company commander to disciplinary authority in connection with the above charge memorandum. If yes, provide the English version copy of special report. Third, whether preliminary inquiry has been conducted, the allegation claimed against the third official, EPS provide English version copy of statement recorded from CPN P report. Request conduct inquiry as per rule 37(1)(b) for availing a reasonable opportunity to defend the allegation and cross-examine the witness in support of the above disciplinary proceedings during the course of inquiry. 5. Provide the proposed copy document intercept with the case file of the disciplinary authority in connection with the above allegation. 6. Request provide SOP standing order for applying leave is online. 7. Whether the third official leave has been sanctioned, leave competent authority or not. Request provide the breakup leave details of SOP with name, that is how many SOP was on leave as of 7/8/2018. How many SOP was present on the unit on 7/8/2018. 9. Whether any complaint received from police station against me. If this, yes, provide English version copy of complaint. 10. It seems from the search memorandum that shortage of manpower of SOP and request provide the breakup details that how many SOP was required for fulfill of duty post. 11. Whether any direction received from CISF headquarters New Delhi that to stop leave to the annual members of the force for Independence Day 2018. If yes, provide the procedural direction copy order.
Yes. Pleadings are completed,
Yes, yes.
then we will hear it. You are not filing a rejoinder.
You are required to, but this need not come to sign one. In the meantime, I will find out. The statement will be for hearing first.
We are admitting and fixing for hearing in the usual.
Pilot actually this record is not required. If you are not desired, then I cannot take it.
We will examine if required, we will see. May keep the records available at the time of hearing. If required, heard learning counsel to the parties. Submitted, the pleadings are complete, admit the hearing. List in the regular hearing list. For the numbers.
Okay.
I put them for 2 hours date.
What the
Hearing
matters?
item-
Who matters?
Two ways.
Hearing item 10.
Yes.
Please take the note.
CD available? Yes. Where is the FIR?
Township FIR is on page number 8. Financial one you don't. Township can be. The crux of the case I just without reading the logic, the crux of the case, what happened in Lordship. On 8th February 23, Naga police received information about the fake Indian currency of rupees 500 denomination. And then they moved to PO Dhunge, where they found 2 persons, Sarapratati and Yaminan. And it has been alleged that one of the accused person escaped from there. However, his identity was not known at the time when these 2 accused persons were arrested. When your lordship, after this, during investigation, the Sarapat Ali took the name of the present petitioner, your lordship. It is a confession made by the Sarapat. On the apprehension of that, your lordship, AB was prepared before the honorable court. Before you were already discharged your lordship, that is an agent of.
FSL available?
But one inspection or verification report is there.
Whose report?
On shift manager of SBI. According to him, it is fake.
No.
FSL is not given.
How has he given that report? On what basis?
But he has stated that, as per note 14 missing.
There has to be a
Yes,
proper.
we have called for
Uh,
FSL report, but it is not in the CDB.
When you get the FSL, So this is only about currency notes.
I have a period to make the option. Several, a lot of time has been given to the prosecution and several dates have been passed. They have failed to bring up the up-to-date.
Therefore, we are calling for this FSL report.
Lordship, I
Our-
didn't protect-
our-
Lordship, I
counsel
didn't
for the-
protect the law.
for the parties. Although the CD is available and APP appearing for the state subjects that the FSL report is not available. Although the same has been called for. Accordingly, let the FSL report be produced before the court along with the CD by the next date fixed.
One minute.
Hmm.
The not in the September, the putting in lottery maybe before 30 August. I will not be.
Hmm.
For medical ground, I'm going outside your lottery in September, maybe date may be given within 1 week your lottery, maybe within 30 August, the number period.
Can you produce within 30 August?
I will try.
No. If you can produce, fine, otherwise,
Lordship, then maybe date may be given after 15 September. your lordship. In that case, your lordship.
all right.
Lordship,
In the meantime, if the petitioner is arrested, he shall be released on
lordship,
interim bail upon furnishing a bail bond of rupees 30,000 with one local security subject to the following conditions. Placed on 25th September for CD along with FSL. Conditions that are.
On orders item 11,
Lordship, I saw that.
Why is it listed for orders?
Well, the matter was hard written entirely.
Huh.
Melody Lordship fixed it on the last occasion, just for passing the order. On that day, my lord, the junior counsel on behalf of Mr. Nair, he submitted that Mr. Nair wanted to make further submission.
This is about
It was relating to promotion from stage 5 to stage 6. From stage 4 to stage 5. Petitioner did not secure 60 marks, which is required to get. That's the reason Melody was found not to be paid.
for 2 years or something. For 2 years.
Yes, okay. Each year, Melody is required to get 60 marks. Melody, the first year he did not get 60, he got 59. Therefore, he was not called for it. The challenge two aspects of the matter, promotion policy as well as the getting of 60% marks. The first part, they ignored at the time of hearing. So therefore, that point cannot be debated.
Yes,
If I see their reply, it was hard and on the basis of earlier round of litigation notice. I forwarded some arguments started and the order itself being 121 and whether that was complied or not fully, that was the issue. The litigation. And my senior.
all right, we'll have it in the second half if you're available.
Second half, the subject to little bit of accommodation, Melody. I'm in a matter in from the team.
Yes. Second up.
Item number 12,
I have a similar, with the item 12 and 13, it will be taken up together. 12 and 13.
12, item 12, so. What is item 12? No, why is it for orders?
well, this matter was finally disposed of. It went up for appeal. The division bench finally reverted it back by.
Interim was there, Lordship. If it was one getting petition, interim was negated, we preferred one negated, that was disposed of. Petition was disposed. Yes.
Readings are complete.
Reading the complete.
So we admit here, we listed for hearing.
Well,
It is before, go for hearing, but Lordship, on 17/8/2023, Lordship, we could put this, they have filed another affidavit in opposition. Lordship may give us the liberty to reply that affidavit. On 17/8/2023, they have filed.
Who has filed?
Respondent number,
then the private respondent.
yes, sir.
Mr. So-and-so learned counsel for the petitioner submits that he required further time to respond to the affidavit. What has been filed?
Affidavit in opposition.
Respondent number was 36.
Affidavit in opposition filed by private respondents.
36, 37, 38, 40, 41. I'll give the number.
By the private respondents, petitioner seeks time to file rejoinder. Prayer allowed list after 3 weeks for admission.
I have a, humble is a prayer lordship. There is another petition lordship, WBC in 1993 or 2020. It's a totally a identical method. So that was
Against the same department.
same department, everything.
It is submitted at the bar that another identical writ petition is also pending. Both the writ petitions we listed together. List this writ petition along with WPC number
1993 of 2020.
1993 of 2020. Let both the matters be listed in the third week of September for admission.
I know.
Supplementary list for orders item 26.
Also, what has happened with my during the, I was appointed as a post of assistant inspector. Thereafter, I was promoted to the post of inspector. Thereafter, my lord, I was demoted. And recovery order was passed against me.
Why is it here? The
My lord, this was
Kohima matter.
this was filed during the vacation. The hearing has been completed. My lord, it may be disposed of today itself, because an order has been passed where we regard, my lord, my confirmation service has been done. I have filed an IA, my lord. Yes, my lord, and I have bringing that on record, my lord. And on that page 17,
Hmm.
may I read?
Yes,
Consequent of the fulfillment of all eligibility criteria for confirmation of service of the permanent post, the under mentioned staff under the establishment of controller and legal meteorology and consumer protection Nagar and Kohima are hereby confirmed against the existing permanent post as indicated here above. The Mizo Monsur Kotsu as the petitioner here in my lord from 10 to 2020.
And what was your prayer in the petition?
To set aside my demotion order and recovery order. So my lord, that may be set aside on the virtue of this order. On page 27, my lord.
Yes,
And my lord, my confirmation may be taken from date of 10 to 20.
what do you say, madam? But why is it before this court?
My lord, because at the time of filing, this matter was, there was vacation in Purima and.
Now there are benches available.
Now, the pleading has already been exchanged, and my lord, this is the, it can be passed, it can be disposed of today itself.
It's a wonderful time to go to Kohima now. As far as I am concerned, from my past experiences.
Actually, my lord, there are the private party who are agreed with the seniority. That is the thing. Otherwise, my lord, he has also been confirmed in that matter. There are a lot of things, my lord. In the order dated 22 May 24. He was promoted, and the promotion is temporary, subject to regularization by the Department of Promotion Committee. So, my question is whether the departmental promotion committee said and they still in the conference because he was demoted, but
Now he's been
whether now he is confirmed.
confirmed.
The motion was also not taken into consideration, I think, at that point of time, it was demoted. But no action has been taken, and now confirmation order has come. Of course, by now, he has already completed 5 years. We have filed our affidavit and placed the reason why he was demoted. He was appointed and.
So
given 3 months time.
what is the effect of this order at page 17 in the IA? By virtue of this, he's been confirmed.
My lord,
So that means the demotion order is gone.
lordship. Then there was an observation being made in the demotion order.
Where is that order? Where is the demotion order?
Another page 27 my lord, of my repetition. Twenty-eight annexes 7, page 28.
That was
It was not demotion, it is an officiating order revoked.
Yes, sir.
revoked.
I was officially revoked to my original post, and thereafter I was.
Lordship,
within a period of 4 months.
3 months.
It's not demotion, your officiating order has been revoked.
I don't hear the now the thing is that matter. If this idea that was 2022 or in page.
Oh,
Already in page 17, this March 15 March 2022 order matter. If this is taken into consideration matter, we have armed appearing for the private respondent matter. We came into the service matter through Nagaland Public Service Commission in 2016. So my lord, our duty, we are the one who, my lord, raised an objection with the department, stating that he was promoted, he was the rule. Now, my lord, in 2022, now it's in the department has given him a confirmation. We will not object to that. Only the thing is that, my lord, his, my lord, entry into this cadre of inspector should be counted from 22.
I know that is.
If it is so, my lord, we will not object.
Anyway, my promotion was temporary, my lord, so if my confirmation is from 10 to 2022, I was not.
If it's counted from 22, my lord, we have no objection, my lord, we will not object to that. Because our senior.
have you received a copy of this IA?
Yes, ma'am.
This, it is reflected the date of effecting confirmation.
Thank you.
My lord will observe this in the order, my lord will not object. It may be disposed of. Only the ballot, our experience in that ballot, if his date of promotion from 2000 initial, whenever in 2014, if it is given effect to that, then my lord, our seniority will go my lord. That's the problem. If it is counted from 22, we have no objection, my lord. My lord will clarify that in the order, my lord, and we have no.
What is there to clarify? It is
Yes,
there in the order itself.
My lord, the only thing that is there, my lord, this because of the recovery order that was passed and that was been stayed, that has to be being made absolute. My lord. And my confirmation from for the post of inspector from 10 to 22. It is confirmation from 10 to 22.
My lord, the thing is that this confirmation comes without DPC. That is the problem.
You are not challenging it. It is open for you to challenge it if you want. State is not objecting. After all, it is an order of the state.
My lord. Like my lord, we are, he didn't want to give him a my lord, passage, my lord, we do not dispute. That is the,
You take your instructions, we'll take it up on Friday.
my instruction is that, my lord.
Huh?
My instruction is that.
All right, hard learned counsel for the parties. This IA has been filed to IA 2216 has been filed to bring on record the order dated
15 months.
15th March 2022, whereby 8 what are you?
My lord, I am inspector.
Controller.
My lord, first one, he's on Montpellier question. 1 minute.
8 officials have been confirmed against the existing permanent posts. Stop. The name of the petitioner as an inspector appears at serial number 1 and he is been shown to be confirmed in the post of inspector with effect from 10/02/2022. Stop. The writ petition 7213 was filed by the petitioner at a time when the petitioner was given officiating promotion, the post of Inspector Legal Meteorology and Consumer Protection, Kohima, Nagaland. Stop. This position is sought to be revoked by the order imbued in the writ petition being order number so and so dated 16 December 2021, whereby the officiating promotion of the petitioner to the post of Inspector Legal Meteorology and Consumer Protection, Kohima, Nagaland, was revoked as per the directive of the government letter number so and so dated 12/10/2021. He was, by the same order, he was retained as Assistant Inspector in the Office of Assistant Controller, Legal Metrology and Consumer Protection. Stop. What was sought to be recovered?
My lord, at page 27 only, annexure 26, initial necessary action for recovery of pay and allowance. My lord, that part has been stated by this honorable court also, by this order.
The
We need to continue.
recovery of pay and allowances enjoyed during the period of the petitioner holding officiating charge of the post of inspector, which was considered to be the irregular period of service by the department, was sought to be recovered. Stop being agreed, the present petition was filed, praying for appropriate and adequate orders. Stop. Notice in the matter was issued on 22/12/2021 and till the returnable date, the recovery sought to be made was stayed. Stop. We said interim order was extended from time to time. So. The respondents have filed their affidavits containing disputing the claims of the petitioner.
My lord will record there are three, my lord.
Where is, you're on whose behalf?
I am for my lord, 8 to 12, my lord. 8 to 11, my lord. Private referendum. In para 3, we have stated, my lord, that we came into service with the victim from National Competition Commission, my lord.
You were given officiating promotion from which date?
My lord, officially promotion from 2010 to 2022 only.
10 to 2020.
Because earlier, my lord, I was promoted in temporary basis.
Stop. Amnesty Pro, learned additional AG appearing for the state summits that this order has been issued by the department confirming the promotion to the post of inspector so of the petitioner. And the date of confirmation is reflected in the order itself. Stop. Therefore, submitted that no further cause survives in the present petition. Better, Mr. R. Hall, learned counsel appearing for the private respondents,
8 to 11.
also does not dispute the a respondent, private respondent, the 211 does not dispute the position, the factual position, in as much as the learned counsel submits that the apprehension of the private respondents were with regard to the seniority which may have been conferred, which might have been conferred to the petitioner. Now, which could have been conferred to the petitioner by virtue of his holding charge of the post of inspector so and so. Stop. However, since the present order dated so and so, that order dated
15/3/2022.
15/3/2022 has been issued in favor of the petitioner, and his date of confirmation is shown as 10/2/2022.
10 to 2022.
For one, they have no grievance insofar as the claim of seniority of the petitioner is concerned with effect from 10/2/2022. Anything else?
My lord, may I just record our entry to service, my lord. It's in para page 45, my lord. We are in 2016. From different date, the annexures, my lord, I will just read out. 28/1/16, 7/4.
You're referring to?
My lord, page 45 of my affidavit, filed by the reference number 8 to 11.
What are these orders?
These are, my lord, our appointments, my lord.
What relevance has it got?
My lord, just to reflect that we came to surveillance 2016. As it is spectrum, our entry.
Orders of the court must relate to the disputes. Our passing observations may cause problems for us also. So therefore, it is not relevant to reflect your date of entry because you're not questioning it. And you agree that his seniority will be from 10 to. So we are leaving it open for you to agitate in Kohima if you want. In view of such submissions made by the parties, by the councils of the bar. Since the advance of the petitioner has since in view of the order dated 15/3/2022, the petitioner has been permanently confirmed in the post of inspector Department of Legal Metrology and Consumer Protection, Nagaland, Kohima, and his date of effecting confirmation is shown as 10/2/2022. No further cause survived in the writ petition. Stop. The recovery order sought to have been made on the ground that it was on the ground of unauthorized, on the ground of, where is that recovery order?
My lord, page 27. the former-
The recovery sought to be initiated of the pay and allowances enjoyed by the petitioner for the irregular period of service also does not survive in view of the confirmation order dated 15/3/2022. So in that view of the matter,
My lord,
the interim order which was granted earlier stands confirmed and is made absolute. Stop. The writ petition therefore stands closed in terms of the above order.
my lord, this order also has to go in, but to 16 plus 20.
Huh?
Page 28 order, 16 plus 20.
In view of the impugned order, in view of the order dated 15/3 passed by the, issued by the authorities concerned.
My lord, if this order goes, my lord, then it becomes, my lord,
Page number
28.
28. The order, impugned order dated 16/8/2022 has lost its significance and it will therefore cannot be enforced during the currency of the so and so order. 15 March.
16, 12, 21.
No, we are saying this order has lost its force.
16 plus 20.
So it cannot be enforced during the currency of this 15 March order. The petition disposed of in terms of the above, IA disposed of in terms of the above. Further agitation you carry on in Kohima. If you have.
On hearing item 13,
Second half, all matters can be taken up in the second half. This is almost over. It is virtually over. All right, we'll keep it at second half.
item number 14,
I'm paying on behalf of Mr. A.M. Haloy. Mr. Haloy suddenly left the court for his daughter's sake.
It's a very old matter, madam. 2012 matter.
I think from me, so many times he's like, communicated this line, but unable to.
What is the matter about punishment? Promotion matter. Mr. Decca is appearing for refinery
No, there is very good.
and Mr. Haloy.
On the number.
Respondent number 9, Mr. Haloy.
This is, we are not concerned with this. This is between you and your clients. Up to you. We can hear it in the second half. If you want. Or he's expressing some difficulty today.
He has difficulty. He forgot it.
We can begin hearing you if you want. Or we take it up on, give us a date.
Instead of piecemeal, we got everything completed in one go.
Sorry,
Instead of piecemeal, we got,
all right,
let it be in one go.
all right. Give us a date. At the request of MS Swanson, London Council, hearing on behalf of Mr. K. Puri, representing respondent, I attest a jail for the day, as it is submitted that Mr. Habu had to leave court because of some medical condition arising in the family. Mr. S. Kotoki appears for the petitioner, Mr. Deka appears for IOC. Date. 19th of September. 19th September. Item number 15. What is the issue, madam?
They are seeking appointment of this election lottery. And we can find out executive lottery where it is stated that there was some anomalies in the selection process lordship and which has been again.
Advertisement of 2009.
Yes, lordship, and it has no relevancy to this.
Then you call for the council if she's available, who is available if you know. We'll take it up. We are scrolling for it. We'll take it up at 2. Again. 16. Yes.
Penalty was imposed on the petitioner to promotion for 2 calendar years were withheld. He challenged, he put it under challenge in his petition, and also my promotion was also put under challenge.
Then,
And for the private response.
then,
Now, the lordship is page 15, the age of the petitioner, I was 54 in the year 2012. And I was 55 in the year 2012, and both of us have retired.
he may have retired, but his promotion was withheld. So if he has a claim, then we can be,
Certainly, but if the e-manager is really shown in the court,
who's there otherwise?
in listed after such a long time.
We'll call it up at 2 again.
Taken at 2 p.m.
Why?
And the other production. It's in positive time before last time.
Revenue Department. You have not released salary.
In this case, this petitioner has filed another petition. It is also pending, very similar appearance.
Huh. What is the number? You get the number?
252 of 2021.
Order, take out the order. 252 of 2021.
Yes.
Take, see what is the status of it at 2. Item 18.
Senior raising for any passport to the tank.
Who is on legs?
My senior, anyone.
Who is for the respondent?
We are from respondent number 5.
So file. Item number 18. 18. Okay, all right, we'll take it up and. All right, item 17 at the request of Mr. Dearishli, who submits that matter has become infractious. Matter stands dismissed as not pressed. Interim order, if any, stands vacated. Mr. Salman Purvai is for the respondents.
Please step to item number 1. Files are there.
No, see what, we have 2 or 3 partner matters, so we have to give the preference to those partner matters. So we can see if
We also have a limited account in the hospital, pick it up,
it's up to him if he permits, so we have no difficulty.
So far, these parties, my figure. The city might contain everything, whatever that is already part of its proposed notice and everything. Like, proceed first matter, they have to require matter, any matter, negative.
For a matter which requires a full-time hearing, ordinarily should be taken up as a hearing.
Already we have started our hearing.
Hmm.
In the midst of the hearing, when the inquiry report was referred to, your lordship has found that
But
only.
now again, the inquiry report will have to be gone into, you'll have to, you intend to take up the inquiry report, go through the inquiry report.
And in the inquiry report, on prima facie perusal of the inquiry report, your lordship found that documents have been exhibited without any discussion on this.
That's right. That's right. When do you want it? At a date of.
26.
26.
26.
September.
26 August.
September.
Virtually.
21st, we'll keep it on 21st September.
Madam,
21st,
madam,
and you prepare your synopsis or argument, whatever you want. On that day, we'll try to
Only I
complete
was
the matter.
request my friend to see, just to see the procedural formalities have been completed. That will make my things easier. I'll just sit here and look at it.
Wherever you sit, this is between the two of you, not for the court. Yes. List on 21st September.
Timing item number 11. What a kind of the.
Why is it for orders?
In fact, your lordship heard the matter.
Uh,
And the lordship possibly wanted to pass the judgment.
The counsel to the petitioner.
They had some problem in the earlier picture. So my learned friend was reportedly he was arguing for one.
All right, we are keeping aside for time if he comes.
Item 13.
Same ground. You had completed your part. So the respondent is supposed to give a reply.
They don't be given the reply, only the report part comes, report given to produce. You know, I both the time, two occasions.
Yes,
So if we close the matter in the meantime, funding the report.
yes.
Lordship, the recording of the.
Yes.
Lordship, we fix it. Some other day, Lordship.
What is this partner matters? 2013 matters.
Only record they will funding to your nothing or nothing to close the matter. Unless they have.
Take it on Thursday, let us see. Thursday. 24. Based on 24 as counsel for the respondents not available in court. The request is made for a password.
Item number 15.
Here's. Concern 15. In regard to data for a Dolby Patna village. And the private respondent is a resident of their village. Accordingly, you have been given. And for us, not say, the petitioner is an outsider.
Petitioner is a resident of.
It's a resident of Puplogao, Doloni Patna. But in our academic it is observed that there is no village as Puplogao, Doloni Patna, but there is a village namely Itapara, Doloni Patna in existence. And AWC is named for, concerned AWC, okay? It's named for Itapara, Doloni Patna village. And on the other hand,
Where is the advertisement?
advertisement, let's say, is the page number. Page number 19 of the deputation.
Where are the centers? Where are the centers?
What's it? Okay, report to the assembly petitioner. Because this Angarwadi center is in regard to that Itapra Dolini population. The center of the Angarwadi is in Itapra Dolini population.
He is a resident of Doluni Pathar.
No, he is a resident of Lordship Puploga Dolini Patna Angarwadi center. His Lordship is previous to see.
What is that page 25?
Yes, page 25 is the order, Lordship. And Lordship may see the last part of the second paragraph, Lordship. As per the report
No, page 25 is a list of,
It's an extra four also.
no, annexure 5. Page 25,
The list.
list. So this is signed by the circle officer, CDPO. And serial number 8,
Yes, food log,
and name of the petitioner appears. It appears.
Yes, so dispute is not a single. That's what, it is not, it's from food log, the delivery. Not way here, we have to consider it up on it, the thing is actually. You are not saying without the food dog. You are here, we have to say, Itapara only for. Also may see page number 25, the previous page was it, the order, the last portion. During hearing that CDPO.
Kindly come to page 15, paragraph 15, page 11.
Page 15 was it?
Page 11,
Yes.
paragraph 15.
That on 27/11/2009, the project level selection will prepare the list of successful candidates. On merits, where the name of the petitioner appears as successful candidate as selected and promoted worker. Number 47, food log of the only partner, for the reason this not to the respondent from it, they appointed the respondent number 8, who is apparently and outside the denying the selection of the, but this is his content from logic, content of
No, this is on the basis of that select list.
the annexure 5.
Annexure 5, the name appears, the selected candidate. Name of the party appears as selected candidate. Anyone for the respondents? Private respondent?
I'm confused about it. Because Dikesh Somar was earlier standing for the social. So it has to be MTM Sara.
How many posts were advertised? Okay. So nobody appears, none appears. Dismiss non-prosecution. Mr. There is someone who appears for CK, someone who appears for the respondents. Yes, sir.
Item number 16.
None appears. Anyone for the departments? What do you say? Hmm? No, that is all right,
In their,
but this claim is with regard to promotion.
yes, in the Pitan court has come for the very motor law. And very motor is yellow. Like, you know, they are really getting the pension. That's like,
um, there was an appeal filed. What is the status of the appeal? Can you get it? Page number 28. You inquire and get us the status of any orders passed pursuant to the appeal. This is an appeal preferred by the petitioner on 8/2/2000.
that if it is pending law, in that case, this petition will not be pending.
Subject to you getting such instructions.
No, the appeal is there. If the appeal
So appeal is there, it must have been disposed of by now. Perhaps some order may have been passed. None appears for the petitioner on hold for the second time. Mr. K. Nayak appears for P. Nayak. Appears for PWD. Mr. Bharadwaj appears for
This one now five.
respondent number 5. The writ petition is filed with the petitioner challenging the order imposing minor penalty, imposing penalty of stoppage of increment.
no promotion for 2 calendar years.
No, sorry, imposing penalty, withholding his future promotion for 2 calendar years. Passed by the competent authority by the order dated 13th January 2012. This court had by order dated 7/12/2012 and granted interim order staying the impute notification dated 13/1/2012 until further orders. Stop. The interim order is still continuing. Stop. From the pleadings available on record, it is seen that an appeal dated 8/2/2012 was preferred under Rule 15 of the Assam Services Discipline and Appeal Rules 1964 before the statutory appellate authority against the order dated or impugn order dated 13/1/2012.
13/1/2012.
As well as the show cause notice issued. Stop. In the absence of the counsel for the petitioner, the status of the appeal or any order passed thereon would not be asserted as such. Stop. As such, Mr. Nayak, learned standing counsel PWD, is requested to procure the necessary information as regards the status of the appeal filed before the authority.
Appendix page 36. That status is there.
36.
Serial number 8.
Hmm? Very well, you get it. Some final inquiry, final, on the basis of final inquiry. Status of the appeal or any order that may have been passed by the concerned authorities in the meantime. Matter be listed after, may be listed next week. You can get it next week. List again on 29th.
Item number 18. I am for reference number 5. The case is not eligible because they have not taken the order. To which the distributor found that she unfit, not eligible to get appointment as the Anganwadi worker. It is reflected in the evidence of the director.
None appears for the petitioner on form. None had appeared for the petitioner earlier on. When the matter was called on 24/05/2019. Mr. Mahmood appears for the respondent number 5. As such, the petition is dismissed for non-prosecution. Interim order if any stand needed.
Item number 19.
Where is that order? Yes, irrigation, who's appearing for irrigation department? Yes, madam, we have another matter for you. Where the respondents have not appeared. Please obtain the instructions. Mr. Hopper. Appears for the petitioner. This contempt petition is filed alleging willful disobedience of the directions contained in the order dated 9/11/2011, whereby the respondents were directed to consider the case of the petitioner in terms of the order dated 31/01/2009 passed in WPC 5190/2009 within Saraswati Kalita versus State of Assam. Stop. The respondents were directed to consider the case of the petitioner for creation of supernumerary posts towards entitling the petitioner of a family pension. Stop. State order not being complied with, the petitioner has filed the present contempt petition. You are not in touch with your client. Huh? The respondents are not represented. Therefore, court has requested MS Bhattacharya, an additional government advocate, to obtain instructions from the concerned departments, namely the commissioner and secretary. Do you have a commissioner and secretary in irrigation? Mainly the irrigation department, government of Assam.
Yes,
Commissioner and secretary irrigation, as well as commissioner and secretary Department of Pension, Public Grievance, etc. Stop. Let the matter be listed after 2 weeks. Copy of this order be marked to the learned additional senior government advocate, enabling her to obtain the instructions as directed by the court. The name of the government advocate be also reflected in the cause list by the registry on the next things. When can you get it?
After 10 days, not
8th
8 not.
8th of September.
Lordship.
Item number 20.
Yes.
Matter which Dr. Bhagan linked the other day. That will CRPF matter.
We have, I recollect, yes.
Malani pen will have.
Yes, please do.
The petitioner raised some point about it that violation, there is violation for procedure that no video presenting officer was appointed, no defense assistant was there. Not in that legal lordship, my submission is that in the main writ petition, there is no any respect to that legal. It was only in the rejoinder that was filed only after the I filed the some translated copy of the record that has been so, but to raise a point in the rejoinder that there must be some substance in the main writ petition.
On
In the writ petition, nowhere.
on what basis are you making this submission?
Lordship, he has not raised this point in that
No,
defense assistant was not appointed.
Matter, we are in the process of hearing. He's raised it in the rejoinder means the matter is before the court.
Lordship, I will satisfied in that legal.
Yes. Let me just, before you give a reply, let me just get a quick recapitulation of the argument, just in short.
My basic is the infractional group rules 87.
Hmm?
Infractional rule 87 of the CRPF rules,
Hmm.
1955. But I have made a specific statement in my report that there was a violation of the mandatory rules of the rule 27. That I have made, and not violation of the principles of legal justice. So those
Why rule 27 is
rule 27 is not binding for the reason matter. Initially, after charges are read, how to the person concerned, the delinquent. My lord, he has to be asked, but after he is the charges are read to him, then he has to ask whether he feels guilty or not. That's the initial requirement
rule 27
of the CRPF. It is in the C, madam.
C1.
C1. The charges are to be reduced in the form of writing. And my lord should be read out to the accused. And a copy of that should be given to him at least 48 hours before the commencement of the inquiry.
Hmm.
Now, at the commencement of the inquiry, the accused should be asked to enter a plea of guilty or not guilty. So this is where the first violation comes in. On 12th, my lord, the inquiry starts. On that day, my lord, not a single question was asked.
No, this, you are raising this issue to, see, there are two issues.
Yes.
One is violation.
Yes.
Or let us say this not following the rules. To what extent is it amenable to judicial review? Is it a simple case that it must be followed in toto? Or is it a case that assuming it was not followed, the prejudice caused to you has to be raised before the
My
court?
lord, there are judgments of the Supreme Court which said infraction of rule 27. Trial is a.
You have to rely on these judgments.
Those judgments are reliant on that, they're right. Those are again those reliable.
Hmm.
So the first one is that rule, infraction of rule 27, so judgments of the Supreme Court, which is the first.
Hmm.
Here, what has happened? The first thing that is required to be done is that he has to be asked whether he pleads guilty or not. That is the initial requirement. On 12/9, he was asked some questions. That will not find at page 104 of the detailed affidavit.
There, my lord. Some questions were asked to him on that particular day, whether he understands Hindi, my lord, and other things, my lord. But this precise question was not asked.
What precise question?
That whether.
Whether he pleads guilty.
Yes.
Yes.
So I will come to the other infractions, later on, but strictly going to the roots, my lord. Then, my lord, after he, whether if he doesn't plead guilty, my lord. Then, my lord, the evidences are to be levied.
Hmm.
My lord, the statements are to be recorded. And after the evidences are levied, my lord, he has to be again asked, my lord, whether he pleads guilty.
Hmm.
If he pleads guilty, then, my lord, the case is to be closed.
Correct.
And if he doesn't plead guilty, my lord, he has to be asked, my lord, to, if he wants to use evidence, he has to use evidence. And thereafter, my lord, he is also been given opportunity to file his written statement. Further, then he doesn't plead guilty, he has to be given the opportunity to file a written statement. And thereafter, he's not evidences are taken.
All right.
So
Now,
here, in this particular case, my lord,
the first question was never put,
not put. Then,
but
my
you
lord,
were given an opportunity to file.
no, that also not given. I come to that. I was not given an opportunity to file a written statement. That's my second living part. Then, my lordship will see there are some questions that put, my lord, by the inquiry officer. No departmental, no presiding officer was appointed. And the departmental inquiry officer acted as both the judge and the prosecutor.
Yes.
So the departmental inquiry officer, my lord, examines one witness, my lord, one R.D. Yadav.
Hmm.
On 15/9.
Hmm.
On 15/9/99.
Hmm.
Here, my lord, he puts this person to some leading questions.
We are not supposed to examine whether these are leading questions or not leading questions. Why should we?
One of the judgments, my lord, that is also referred to this.
There are subsequent judgments, later judgments, where it says that if there is some ingredient,
My lord.
that is sufficient.
I'll put that.
Not we are in 24 years after.
No, no, listen, my arguments are twofold, my lord. Procedural violation is already there, no? I've told that there's a procedural violation. But otherwise.
How old is he now?
Hello?
What is his age
No,
today?
he will be about something 57, 56, 57. He will have very not
And what is the age of superannuation?
supervision 16.
Hmm.
But what had happened here, the departmental, because this is relevant, because departmental inquiry of the inquiry of the cannot be acting as a prosecutor.
Very well, we have noted that.
Yes.
Then,
He asked him leading questions, my lord. Then, my lord, two witnesses are examined. The second witness to examine, my lord, since that's the reason I did not point out all these things of the other day, my lord. The second my lord, person who was examined, my lord, he doesn't say anything about the petitioner. He doesn't implicate the petitioner in that way, my lord. That's the reason I did not go into all these aspects on the other day when I was arguing this matter. But my lord, in fact, the person concerned, my lord, was supposed to attack.
if we hold that there was no presenting officer and therefore it is bad, then these other issues are not
No,
necessary.
that's the reason I didn't go. into-
Assuming we don't hold,
Yes.
or assuming we hold, but we also hold that in spite of that, there's no infirmity.
No.
Then the question of sufficiency of evidence, can we look into and to what extent?
My lord, that's the reason that I was not going into the audience. But then. my
No,
lord,
no,
to
we
certain
are-
extent-
we are-
Yes,
We are trying to understand what is your submission. Is it your case That no, the court needs to go into each and every evidence.
My case is, first of all, because the procedure regulated.
We have noted the procedural regulations.
Second, even if it is seen from the other from perspective of evidence, then also the evidences are not there, my lord, because when this really
What is the allegation?
allegation, my lord, is that there was a lot, they were intoxicated, my lord. They had entered into the water of one of the commanding officers, ransacked it, my lord. Then they went out and did something in the public, they gave some public vehicle, or gypsy car, and also tried to create nuisance in the public, in the police station. Now, there was a criminal charges against him, criminal case against him, where he was acquitted because of no evidence being there.
Can be a ground not to proceed merely because he's intoxicated, criminally acquitted.
No, had this judgment come before, then the thing should have been this. But this judgment came after this disciplinary prosecution.
Which judgment?
The judgment of the tribunal of criminal court, the criminal prosecution. That came
No, even if the judgment of the criminal court had come earlier, is there a bar? No.
then they were possibly taken sanction of the higher authority. That was required. But since it came afterwards, perhaps that will not be that was not relevant at that point of time. But the fact is that in that particular case, no evidence was led and he was acquitted. Now, in this particular case, the presenting, as I said, presenting officer was also not appointed, and I was not given the opportunity to file a written statement. I was not given the opportunity to file a written statement. My case is that.
But you left the premises.
Yes, madam. That I'm coming. That's my next permission I will take. I had to leave the premises under threat, madam. I was not even given the basic food and shelter, madam. And basic amenities as well. That's a specific statement I have made. In paragraph 17, madam, I have made a specific statement that the inquiry was conducted ex parte against the petitioner on the ground that the petitioner became deserted during the inquiry. Proceedings in this context, it is pertinent to mention that the petitioner had to leave the inquiry proceedings under oral threat of dark and direct consequence at the inquiry officer and other vested interests in the absence of minimum facilities or way of putting in law. So the conditions were made such manner that I had no other option but to leave the inquiry in between them.
And you did not inform anybody.
I did not inform.
Neither any complaint rose to superior authority.
I left that. Because I was scared a lot and I left it. Because my lord, what you can see, I came with the intention of attending the inquiry.
You were brought.
No, I was called when I came. I was called when I came. And my lord, during the first day, my lord, when the questions were put, my lord, I answered the question.
He was not arrested.
No, man.
He initiated they sent a suspension on 7/8/98. Then charge memo was.
No, he went away.
He left the place on 24/5/99. Then thereafter he again changed lordship on reported on 10/9/99.
On his own.
And German, after he issued some memo to the local police station. Thereafter he appeared.
All right.
And again he then after 2 days he again left.
No, my lord, initially that's what I'm saying. But 12/9 when I was before the inquiry committee, I my lord had specifically answered the question that were raised. There was nothing to show my lord that I had refused to answer any question. Suddenly on 15, my lord, they say my lord, I refused to cooperate with them. But this is from their own records. What happened in between these 2 days, my lord, is something, my lord, because that will show, my lord, that
How many persons were charged?
4, my lord.
4.
They were separate. It was separate. It was tried separate.
What happened to the other 4?
They are also dismissed.
Dismissed.
So those, my lord, initially, my lord,
But they are not before this court.
I don't know. Because
No.
though initially, my lord, it was said to be a joint inquiry, my lord, and it was segregated. I was separated, my lord.
But the witnesses and everything were safe.
That looks like.
No, lordship, they are proceeded under section 12 because the commandant can exercise magisterial power. So since they were convicted and subject to 2 months simple imprisonment, on the basis of that conviction they were dismissed.
What conviction?
Under section 12 of the CRPF Act.
And insofar as the petitioner is concerned,
He was tried separately. Section 12, okay. Every person sentenced under this act to imprisonment may be dismissed from the post. Since they are in prison for 2 months, on the basis of that imprisonment, they were dismissed.
In fact, well, the persons, well, the officer who's office I am supposed to have consent. In his initial statements, well, are totally different from what was well, his statement because well, given the living questions. He well, directly did not say.
where are these statements?
I mean, these are the end record, but they have been the project signal.
All right then,
Well, I was not given an opportunity, well, when I was even asked whether I wanted a defense assistant because well, I am a constable, well, and well, I have got no idea of well, this proceedings, well, and I was pitted against well, higher officers. Therefore, well, non-giving me a defense assistant well, also.
Is there a circular? CRPF?
Well, we have circular.
In fact, well, what is the name of 102, well, rule 102 of the CFF rule says that if whatever is not prescribed, the CCS rules will come into play. There, my lord, defense assistant is speaking.
In the CFPF Act, no, there is no provision of defense assistant or in the presenting officer, it came up only in 2011. We have issued a circular making provision for presenting.
My lord, the possibility rule 102 of the CFF rules. It says that where it is silent, the my lord, central CCS rules will come. In fact, my lord. Here, my lord, I was, no defense assistant in my lord. The allegation is that I was intoxicated. No medical examination was also done. They did not even bother to do doing medical exam. This record doesn't reveal anything, my lord, so far that any medical examination was done.
Yes.
Now,
then-
as per the rules, so after he, whether if he doesn't plead, if he gets to ask whether he is guilty or not, thereafter the evidences are related by the prosecution. Now, what has happened here, my lord? They have relied upon one questionnaire, set of questionnaire, taken 15-9. Whereby, my lord, they say, my lord, that I was asked this question, not the first time. After 2 persons are examining, this question was asked to me whether I plead guilty or not. And their contention is that I refuse to either plead guilty or not plead guilty.
You did not answer anything.
I didn't answer. But then
there are, the materials will show that two other witnesses were examined thereafter. So these questions ought to have been put after all the evidence has been laid. Even assuming that I did not answer. For argument's sake, let us assume for a moment that this question was asked to me and I did not answer. So I'm denying it, but for argument's sake, if I say that these questions were asked, even that was done in between. Therefore, there is clearly, it is evident to the records that this procedure was not being conducted in the same manner. Their own records will show that some of the witnesses were examined on 15, 17. And if these questions were asked on 15, then before even completion of the examination of the prosecution witnesses, there was no question of putting these questions in between. And all these were causing prejudice to this question with the low length and drawing manner, a constable manner. And my lord, my case is that I was under tremendous threat and pressure, my lord, for which I had to leave the proceeding. Surprisingly, another thing, my lord. On 16, I am supposed to have resided on 17. I go missing.
When was the question? When was the questionnaire given to you?
My lord, as per them, 15. Where is your refused to answer? That is the 115, 115.
15/9?
15/9/99. My lord, page 115.
One 113. Page number?
115.
Yes.
Now, I was still in the barrack, my lord. And according to them, my lord, I had resorted on 17/9. But on 16/9, my lord, they sent a communication, my lord, by registered post. Though, my lord, no postal receipt except or anything has been attached. But they, my lord, sent a communication to me, my lord, by registered post. When I was still there, my lord, in there, my lord. Because as per them, my lord, I left on 17. So what prompted them to write this letter on 16, my lord, is another mystery. And as I was saying, your lordship, that on 15, my lord, this questions were asked, my lord. Lordship will find at page 136. On 7/10/99, my lord. Again, my lord, witnesses were examined. So, my lord, this question, my lord, whether I plead guilty or not for the second time, it is to be asked. That was to have followed, my lord, after 7/10. But in between, on 15/9, after examining two witnesses, they say that they put me this question, which I refuse to answer. Then, my lord, they again refuse to examine other witnesses, my lord.
So were these questions put to you or not?
Which questions, my lord?
These questions of which were put to you on 17 or 15/9.
No, well, my case is that first of all, there are no questions. And what was told in the inquiry, my lord, is that you plead guilty. Otherwise, they are not going to do anything. You have to plead guilty. In fact, this my in my reply I stated that I was forced to not plead guilty, or otherwise, not they say that deal with it. Now, on 7/10, my lord, this witnesses are examined. Now, my lord, I have to be given at least 15 days time to file a written statement after the evidences are ready, and I plead not guilty. Now, there is nothing on record to show my lord that I was given this opportunity of 15 days time to find my vaccine.
15 days is prescribed under the act.
Under the act. Rules, fine. 27, rule 27 is that. Rule 27, my lord, C4. First, they have to leave their evidence. Material to the charges even have been laid by the prosecution. Then when the accused shall be examined and his statement be recorded by conducting an inquiry. If the accused has pleaded guilty, doesn't challenge the evidence of the court, the proceedings shall be closed for others. If it is not guilty, he shall be required to find a written statement and a list of such witnesses as he may wish to sign in defense. Within such period, which shall in any case be not less than a fortnight, as the officer commanding inquiry may deem reasonable in the circumstances of the case. If he declines to find written statement, he shall again be examined by the officer conducting the inquiry and expiring the statement. So there are two witnesses were examined, one on 7th and on 16th, and thereafter I was asked this question whether I plead guilty or not. And if I do not plead, I say I am not guilty, then I have to be given an opportunity to find a written statement. This 15 days time is to be given. Now, on 16/10/2099, they makes a letter, which is supposed to be have been sent to me, asking me to find a written statement. But no postal receipt or no ID card of that particular letter is next to this records which have been furnished. That your lordship will find it page 143.
Yes.
So this letter is not supported by any supporting document that assuming because their case was at the station, so they had to send me by registered post letter. This letter dated 16/9/99 and actually U page 143. It is it ends at 145, but there is nothing on record to show that this letter was indeed sent to me by registered post letter by annexing any postal receipt or for that matter acknowledgement card.
Yes.
Now, you will find the inquiry report at page 146. There is no date map. The inquiry report does not contain any date map.
Yes.
It has got no date at all.
Is there any appellate forum?
Appellate forum, I will went to the appeal matter. That was also dismissed without any application of mine. There is a revision provision I also availed that. But those
Did you urge these points in the appellate forum?
No, these points are not hard this case because I'm not very sure because this copy is not here this case. He has not, I've not been able to get this copy.
Which copies?
This copy of the appeal and this copy. This I couldn't tell before the budget. Therefore, my counsel there is a violation of the Rule 27, which is mandatory to be followed. And is on this background, of course, as I've seen, there are enough contradictions in the evidence. And they have answered in a particular way when these questions were answering on their own. And when they're put these leading questions were put to them by the disciplinary inquiry officer, they answered in different manner.
Okay.
So therefore, my lord, there is a clear case of prejudice also, my lord, which is not apparent of case for the court. So, my lord, the reason, my lord, I am relying on some judgments, my lord, I have given citations earlier, my lord. One is, my lord, a decision of this, of our honorable court, my lord. Sundeshwar Chaudhary appellant, my lord, versus, Union of India, my lord. It is not,
Where is the chart? List of cases? List of cases. Huh? You can hand over one more extra copy.
one copy. This is Sundeshwar Chaudhary, my lord. Here, my lord, I will basically lack of the
No, you can give us the copy, you can give us the list. We'll find
This
out.
I give it other than actually because so I can make the extra copy.
All right. Hmm.
This paragraph 22 to 85, man. The rule 27 of the CRPF rules do not expressly provide for the appointment of a presiding officer. This court in the case of Sundeshwar held that rule 27 does not bar the company authority from appointing a presiding officer in the disciplinary proceeding for conducting the same with fair manner in accordance with the principles of legal justice. After referring to various judicial pronouncements, it has been held that in department proceeding where no presiding officer appointed, the assumed inquiry officer assumes the role of the judge as well as the prosecution. In as much as in the absence of the presiding officer, the inquiry officer must examine the witness and declarative documents, which will be in total violation of principles of legal justice. It is finally held that appointment of presiding officer must in a disciplinary proceeding against the PIP constable. It is in that case, because of the non-appointment of presiding officer, the disciplinary proceeding against the petitioner, who is a constable in the CRPF, leading to the dismissal was declared as illegal and because directed to be in service. In Ram Lakhan Sharma Supra, the issue before the court was removal of the service of a CRPF constable following a disciplinary proceeding, which was performed in appeal and revision.
No, this finally held the appointment of a presenting officer
Right.
is a ratio where in the
In
Santi Kumar judgment, Santi Kumar Singh.
and also in Ram Lakhan has been discussed, the Ram Lakhan case to the Supreme Court, it was upheld. They're all placed. Ram Lakhan Singh are also placed. A division bench of this court has held that even when the statute doesn't prescribe for appointment of a presenting officer in a disciplinary proceeding, then also the same is required to be made to comply with the principles of natural justice. It is the facts of this case. In the facts of that case, it was held that the inquiry officer, in the absence of the presenting officer, had put all the questions to the delinquent. Thus, the inquiry officer acted beyond his jurisdiction. If the authority acts beyond his jurisdiction and submits his report, the disciplinary authority should not act on such report. The court has under. We are of the further opinion that in various disciplinary proceedings, the statutory authority is working like an administrative authority. When they have to act independently, they discharge the duty as the statute prescribes anything. Prescribe applying their judicial mind. It is a settled proposition of law that a disciplinary proceeding is a quasi-judicial proceeding. And the inquiry officer, when acting as a disciplinary proceeding, is likely to is to act like a judicial authority. We have the further opinion that the inquiry officer should not act either for the disciplinary authority or for the delinquent officer. He is to act independently to take the inference of facts which is placed before him by the parties. He should not put cross questions to the president like a presenting officer to the delinquent officer to prove the charges leveled against him. Against the delinquent officer. For such action of the inquiry officer, it can easily be stated the inquiry officer is to extend bias to the delinquent officer, which is unwarranted in law. If the statutory authority acts beyond the power vested in him, then where the delinquent officer will go except for the court of law, which of course really has been taken away by the respondent. With petitioner to prove the biasness of the inquiring officer in the description and ultimately succeeded. So because therefore, then paragraph 25. Does the following above decisions, I am of the view that the failure to appoint a presenting officer had fundamentally affected the discipline proceeding drawn up against the petitioner. In going with the finding recorded by the inquiry officer, the petitioner was clearly prejudiced by such omission. The same has vitiated the inquiry and consequential findings. So here, as I've shown, in this particular case, he was putting cross questions, and the manner in which the inquiry was conducted, he flouting the norms of the rules, right from the go, what goes. This proceedings to be vitiated. And also there was a-
So the ratio of the judgment is that if you don't appoint presenting officer,
yes.
there's a prejudice cost.
And there's Ramlakhan Sharma, but is reported in 2018-7 SCC, Supreme Court. 2018-7 SCC 670.
Six,
Just happened when he was Supreme Court.
2018, 7 is
7 SCC 670.
6-7.
670. Yes, I have a copy. Two thousand 18-7 is 670. I am not this paragraphs might be little different because the copy I'm going to the Supreme Court. The paragraphs may differ a little bit. Here the basically the paragraph number 28 to 9 as far as the proposition of law is concerned, in my paragraph 28,
Yes,
as for the proposition of law is concerned, it is common ground that if the inquiry of operative pleads the role of prosecutor and cross-examines defense witness or puts leading questions to the prosecution witness, clearly exposing the biased state of the mind, the inquiry would be opposed to the principles of justice. But the question for the consideration in this case is whether the inquiry officer did so. It is also certain whether the inquiry officer is entitled to put questions to the witness for clarification whenever it becomes necessary. So long as the employee is permitted to cross-examine the witness after inquiring authority, question the witness. The inquiry proceeding cannot be impaired, unfair. So this is one. Then my lord. Paragraph 32 was again before another. There is some summary for all. This is for the division bench of we may summarize the principal judgment. I will be relying on 16.4. If the inquiry officer conducts a regular examination by leading the prosecution witnesses, though the prosecution states or puts leading question to the departmental witness pregnant with answers or cross-examine the defense witness to put suggested questions to establish the prosecution case, the inquiry acts as a prosecutor, thereby between the inquiry. Then my lord, paragraph last paragraph 35 onwards.
you can't read 4 in isolation, you have to read with 3. You'll have to read with 3,
My
or maybe even with 2.
yes, sir. The inquiry officer who is in a position to judge shall not act as the presiding officer, who is in the position of the prosecutor. It is not necessary for the district authority to appoint a presiding officer in each and every inquiry. Non-appointment of presiding officer itself by itself will not be required. The inquiry officer will, with the view to arrive at the truth of obtain clarifications, can put questions to the prosecution witness as also defense witness. In the absence of the presiding officer, if the inquiry officer puts any questions to the prosecution witness to elicit the fact, you should, they have to permit the delinquent inquiry cross-examining witness on those clarifications. If the inquiry officer conducts a regular examination by dealing with the prosecution witnesses to the prosecution case or puts leading questions to the departmental witnesses pregnant with answers, or cross-examines the defense witnesses or puts suggested questions to establish the prosecution case in case employee, the inquiry officer acts as a prosecutor, thereby getting the income. Here, the question, that's all, I was referring to the questions, but the questions were put in such a way, when the witness was submitting on his own manner, he was submitting in a different manner. And then the specific questions were being put in the mouth, that this has happened, that had happened, and they will not there answering. Then the last paragraph 35, thus the question as to whether the inquiry officer is supposed to act independent inquiry as acted as a prosecutor is not a question of fact which is to be decided, is not a question or not, is a question of fact which is deciding the facts of the particular case. In the present case, we have noticed that the High Court has summoned the inquiry office inquiry proceeding, and after perusing the proceeding, the High Court came to the conclusion the inquiry officer himself led the examination in chief of the prosecution witnesses by putting questions. If the High Court further held that the inquiry officer acted himself as a prosecutor judge in the same case, when it was the above principle, the High Court has already noticed in paragraph 9 and 10 of the judgments of the High Court giving right to the service. The High Court having come to the conclusion that the inquiry officer acted as a judge to the prosecutor also, the capacity of independent adjudicator was lost, which adversely affecting his independent role of adjudicator. In the circumstances, principles of bias shall come into play, and the High Court was right in setting the dismissal orders by giving liberty to the appellants to proceed with the pressure. So in this particular case, also the manner in which the inquiry was proceeded with, and that's why the questions also perhaps assume their importance, the way they were put to the witnesses. He was acting in a biased manner. Then another judgment, this is of the Agartala bench of this honorable court matter. Again, the CIPF matter versus Sri Nirmal Bhattacharya versus that is not I'm giving copy. Here, this paragraph 17 and 18 may be other. In the case, in the instant case, the procedure resulting in the inquiry proceeding was initiated to the reasons recorded above. Coupled with this, it cannot be said to be a case of sitting on appeal on the evidence on record. To hold that it is not a case of no evidence at all, but a case of perverse finding, the minimum exercise to find that the same in reference to the evidence will have to be carried out. While doing so, what has transferred has been noticeable. The learned single judge in his interim judgment and order has dealt with the matter meticulously upon a reference to the material record. There was infraction of Rule 27 of the rules in conducting the inquiry proceeding, which vitiated the same. So the infraction of Rule 27 vitiates the inquiry proceeding, which also my case man.
You're reading paragraph?
Well, paragraph 17 and 18. Then I'll be relying upon another judgment. This is reported to 54 jail. Reader does what it is.
In the Agartala bench judgment, you're referring to paragraphs?
Yes, paragraph 17 and 18. Where we are looking at the evidence, sir. In certain cases, it's permissive to find out whether there is any case of no evidence of purpose finding.
So you read from somewhere that the rule is mandatory?
Yes, sir, next paragraph 18.
Hmm?
Next paragraph 18. The runner single judge in a simple judgment and order had dealt with the matter meticulously upon a reference to the entire legal record. There was infraction of rule 27. This is what Nirmal Patel said. There was infraction of rule 27 the rules in conducting the inquiry proceeding, which vitiated the same.
Kindly come to page 7. Paragraph 7.
Paragraph 7. We have carefully examined the record and don't find anything to show the same because the rule 27 was complied with. By giving a portion of the petition.
This is not the case here.
I might be. I was also not given a portion. That's also my case. That's also my case.
Your opportunity, this is not a case that you wanted to file and it was denied. I don't know the facts here, but in the facts of the present case, it is not a case that you wanted to file, it was not accepted or it was denied. You had a case that because of certain situations which were created in the camp, you were forced to leave. And thereby your opportunity to file written statement, etc. were taken away. So this, can it be said with clear, does it lead to a very crystal clear conclusion that Rule 27 was violated?
No, Rule 27.
You know that you are facing a departmental inquiry. You know, you are expected to know that you are entitled to filing a written statement or some reply for the matter. There is nothing on record to show that you wanted to file it.
My case with the Rule 27
It is not a case that you are not familiar with the rules, therefore you did not know whether you should file or not file.
My case with the Rule 27 is not just about written statement, so that entire procedure respect.
No, correct.
Therefore, yeah.
What I'm saying is, here is a case where Rule 27 was considered to be violated because that opportunity of filing W is essentially, as I can read it.
Yes, that's why, yes,
So in that context, the Rule 27 was held to be violated.
Here, of course, we have seen other aspects also taken into consideration. The procedure prescribed Rule 27 was not followed in the inquiry. The opportunity of filing a written statement as a decision in Rule 24 was not given to the petition. The evidence recorded against the petitioner has not established the guilt, and there being no evidence so as to retain the finding a right to
No, the purpose of putting a query with regard to Rule 27, if Rule 27 is mandatory, to the extent of asking you the question of whether you are guilty or not at the outset,
Yes.
at the initiation of the proceeding, and if there is a judgment to that effect, I don't think we need to proceed.
The next judgment after
The sufficiency of evidence,
next
questions put to you.
next judgment.
Yes.
So not read it as well. Read it. There are these part. Read it as well. Again, the paragraphs might have little different. 18 Rule 27 is read it as well versus United India.
Yes.
Rule 27 is CRPF rules 1955. Now, I'm reading my paragraph 18 level. Quite different in the paragraph number. Rule 27 CRPF rules 1955 lays down the procedure for award of punishment on CRPF personnel
which it appears to have been adopted by the SFB. In the case of punishment or dismissal from the service of constable, the commandant is competent to avoid such punishment to be inflicted after formal departmental inquiry. The procedure for conducting departmental inquiry is based on Rule 27C. A perusal of the Rule 27C shows that the substance of the accusation has to be reduced in the form of writing to precise. The charge should be read out to the accused, and a copy of the same should be given to him at least 48 hours before commencement of the inquiry. After the commencement of the inquiry, the accused should be asked to enter a plea of guilty or not guilty. After which evidences, both oral or documentary, should be taken. Accused should be allowed to cross-examine the witnesses. Accused will also be entitled to make his defense after inspecting the documentary evidence relied upon in support of the charge. Statement of the accused should be recorded to the inquiry officer. If he pleads guilty, the proceeding should be closed to others. If he pleads not guilty, he shall be required to file a written statement and list of such witnesses which he may wish to cite in his defense within such period which shall in any case be not less than a fortnight. If he declines to file a written statement, the accused shall be examined by the inquiry officer despite of the period allowed. If the accused refuses to cite any witnesses in his defense, the proceeding should be closed for others. In case he produces evidence, they should be recorded and considered. After completion of the inquiry, the inquiry officer shall forward his report to base on the records of the proceedings to the commandant, who shall also record his finding in part necessary orders. Thus, from the conjoined reading of Rule 14 of the 1965 rules and Rule 27 of the CRPF rules 1955, it is quite evident that though inquiry was stated to be held under both the provisions of Rule 14 of the 1965 CCS rules were not complied. First of all, the requirement of 14.4 the 65 rules petitioner was not granted time to submit written statement of defense against the articles of charge into the commencement of inquiry. Straightaway inquiry was held within 44 hours of furnishing articles of charge to the petitioner. Though under Rule 45C, 5C, the 65 rules, there is provision for appointing a presenting officer in the case of the case of the disciplinary authority. No such presenting officer was appointed in this case. Coming to Rule 27C of the CRPF rules, the pages of the inquiry report indicate that the procedure prescribed was followed. It is not discernible from the report as to whether the petitioner was asked to enter the plea of guilty or not at the commencement of the inquiry. The inquiry report also does not disclose that the inquiry officer asked the petitioner to file written statement along with this list of such witnesses, which would be relied upon in the defense in the period of less than a fortnight, as per requirement of the Rule 27(2)(c)(4) of the CRPF rules. This is fundamentally vitiated inquiry, conduct of the inquiry with the inquiry officer. So therefore, clearly, at the outset, he has to ask whether he pleads guilty or not. So that,
Mr. Doctor, we are trying to understand the rigors of Rule 27. The fact that there are defects in the process of departmental inquiry is an issue that you will obviously agitate, taking us through the various facts and evidence which came out or not there or witnesses. That is on a slightly different issue. What we are trying to find out is the mandate of Rule 27.
yes. So mandate of
Rule 27 says you should be put to a question of whether you are guilty or not.
yes.
That, according to you, and as is evident, was not put to you on the initiation.
Yes.
Whether it is that by itself requires or leads to the conclusion that the proceedings mandated under Rule 27 has not been followed.
This paragraph.
Because subsequently, that opportunity was, maybe they lost sight of it, but it was put to you.
No, well, this opportunity has been given twice.
Hmm.
That's well, but because mandate of Rule 27 has been discussed in paragraph 18. All these provisions, he has to be asked these questions twice. So here, coming back to Rule 27 in paragraph 20, in paragraph 18, the charge should be read out. First of all,
This is under Rule 14.
no, Rule 27.
You are reading para 18.
No, this is para by different. Rule 18 starts with Rule 18 of the CFA rules. That will difference the paragraph. That's what we will. Para 27 CFA rules.
Rule 27.
Yes,
Yes.
of the CFA rules 1955.
Ah.
Based on the procedure.
Hmm.
for award of punishment of CRPF person, which appears to be adopted by SSB. In the case of punishment of the dismissal from service of constable, commandant is competent to award a punishment be inflicted after further inquiry.
This is CRPF or SSB.
This is the case of SSB, which was adopted by which has also adopted the CRPF. So what has been discussed?
What is CRPF rule as a separate?
Yes, yes.
SSB, they had adopted the CRPF.
And what has been discussed about is Rule 27 CRPF, not that, nothing else. The procedure for conducting departmental inquiries laid down in Rule 27C. A perusal of Rule 27C which shows the substance of the accusation has to be reduced in the form of writing charge, which should be precise. That is number one. Number two, the charge should be read out to the accused and a copy of the same should be given to him at least 48 hours before the commencement of the inquiry. At the commencement of the inquiry, the accused could be asked to enter a plea of guilty or not. So that at the commencement itself, he has to be asked this question whether he pleads guilty or not. After which,
No, see, there is no dispute that it was never asked.
yes.
The question is, it was asked subsequently.
No,
Is it sufficient
no,
to come to a conclusion that the spirit or mandate of 27 has been violated?
that I'm coming to that. That's why the subsequent part is very important. So that after which evidences of both oral and document should be taken. Accused would be allowed to cross-examine the witnesses. Accused also would be entitled to make a defense after inspecting the documentary evidence relied upon in support of the charge. Statement of the accused shall be recorded by the inquiry officer. If he pleads guilty, the proceeding should be closed for others. Now, whether here, if you again, whether he has to be asked this question, because the proceeding begins and takes a Rule 27. This question has to be asked twice.
Yes.
C4 manner. First, C2 is the commencement of the inquiry. At the commencement of the inquiry, C2 manner. At
Yes.
the commencement of the inquiry, the accused should be asked to enter plea of guilty or not guilty. Then, my lord, evidences are to be recorded. C, my lord, when documents are realized, the documents are to be given 3. Documents are to be given to be allowed to be inspected. Then 4, my lord. Then the accused is to be examined and his statement recorded by conducting of the officer conducting the inquiry. If the accused is pleaded guilty and does not challenge the evidence of record, then the proceeding shall be closed for others. If he pleads not guilty, he shall be required to file a written. So after this evidences are examined, reduced, my lord, after his statements are recorded, then, my lord, if he pleads guilty, then.
No. I don't think that is the mandate.
Yes, sir.
No. See, C2
Yes, sir.
is where you are asked whether you are guilty or not.
Yes, sir.
C4 is what happens when he pleads guilty and what happens when he doesn't plead guilty.
Correct.
You're not required to ask him twice or thrice.
No, my
C2,
lord.
kindly see C2 at the commencement,
Yes, my lord.
you will be asked to enter a plea.
My lord.
If he says guilty,
My lord.
now come to 4.
My lord.
If he says guilty, does not challenge evidence, proceeding shall be closed for orders.
My lord.
If at C2, you ask him he is guilty,
My lord.
why do you need to, or where is the requirement to ask him whether he pleads guilty again in C4?
Because of the after the evidence is lagging. Once the commencement of charge.
Once we plead guilty, there is no requirement to lay evidence at all.
No, my lord. Here it is not so, my lord. Here, enter after which this. It's once the commencement of the inquiry and the charges are read out to me.
Then you read 3,
Right.
C3. The documents relied in support, they shall be put to evidence as exhibits.
My lord, then I'll.
Then the accused shall,
Yes.
before he is called to make up his defense, be allowed to inspect. Now, where is the question of calling up his defense? He is pleaded guilty.
No, my lord. Naturally, in the 2, my lord, take 2. At the commencement of the inquiry, the accused shall be asked to, my lord, first is the substance of the charges should be read. The
Correct.
charges should be read out to the accused, a copy of the evening to be given at least 48 hours before the commencement.
Correct.
Then at the time of commencement, at the commencement of the inquiry, accused should be asked to enter a plea of guilty or not guilty.
So he enters.
After which evidence is necessary to establish the charge to the accused. So the first stage, he has to be asked whether he plead guilty on the charges as it stand. And irrespective of whether he pleads guilty or not, my lord, then the evidence is to be used.
Do you have your government publication rules? Government publication published rules?
CFF rule, Lordship. This is,
No, this is by a private publisher. I'm asking you, do you have the government publication?
maybe. I can, I'll send the produce from the department.
Yes, please ask them. Now, if after pleading guilty,
Well, that's positive. If what is following to lordship, for argument's sake, we will take that. So the records lordship will find the law. Initially, there was no question asking whether it was guilty. Then a lot of the evidences were letting. Partially evidences were letting my lord. And if they are to be believed, my lord, this questions was asked, my lord, when even before the evidences were, my lord, completely, my lord, completed. So therefore, in between, my lord, they say that, my lord, to which I deny, my lord. Even assuming, my lord, from their standpoint, that this question was put to me. Let us assume for a moment this question was put to me. Even that was also not done, my lord, as per the rules. After the evidences are letting, my lord, then only the question of, my lord, if this is to be, my lord, this is to be true, my lord, then after the evidence is letting, I have to ask whether guilty or not. My lord. And if I am guilty, not.
this is why repeatedly the court is asking you the rigors of 27C.
That's what.
To what extent?
At the commencement.
All right, at the commencement, then where is the question of asking him for the second time?
Second time.
Why?
That's what I'm saying. Assuming there is no requirement for asking the second time. This question was not asked.
Assuming it was not asked, it was asked in the middle of somewhere
Right.
in the proceeding.
Right.
Where is the prejudice?
Previous because what happened, the proceeding was not followed, process was not followed.
It's not a case of not being asked at all.
Right.
It was a question, it was not asked at the insert.
My case, it was not asked at all.
That is what they are denying.
This is my case. I was
All right,
not asked.
all right, all right. Yes. Now,
Now, my lord, here, my lord, therefore, it is not discernment for 20 now. It is not, it starts with coming to say rule 27C of the CRPF rules 1955. A perusal of the inquiry report dated so and so does not indicate the procedure prescribed was then was followed. So what you will see, my lord, the findings of the court are that first of all, the procedure prescribed in the rule 27C was not followed. That is also my case, my lord. It is not discerned from the report as to whether the petitioner was asked to enter the plea of guilty or not guilty at the commencement of the inquiry. My lord, what you will see, my lord, in this particular case, my lord, from their communication or the questionnaire on 12 night, where the inquiry commenced. No question was asked to me, my lord, at the, my lord, commencement.
we are not denying, we are not, there is no doubt on that.
No.
There's no dispute.
So
They
they
were not asked.
So therefore, my lord, the inquiry report did not inquire.
According to you, it was never asked.
No,
According to them, it was not,
never asked.
it may not have been asked initially at the inception.
Yes.
Subsequently, these questions were put.
But even then, my submission is that it was not in conformity to the rules. The rules required that, my lord, that it ought to have been answered at the commencement. And, my lord, my case is that it ought.
But if we accept your interpretation, that it needs to be asked twice.
Right.
Then assuming the first time it was not asked.
Right.
The second time, if it was asked, substantial compliance is there.
Well, my submission will be, my lord, if it is not asked at the commencement, it will not be
All right,
initiated.
okay, then
Then, my lord, the inquiry report does not disclose, my lord. At the inquiry officer, asked the petitioner find written statement along with this list of such witnesses, which would rely upon his defense within the period of law.
no, that is okay. The rest of the issues are not in.
Yeah, an officer, no presiding officer of the point of view of the.
Presenting officer.
Case.
Presenting officer.
Yes, ma'am, presenting officer.
Yes. This is also not in dispute.
Not understood. So therefore, this is also appreciated the procedure. Because, madam, as I've said in rule 102 of the CFA rules, madam,
Hmm.
if anything is not there, then the CCS rules have been followed. So CCS rules, under CCS rules, this is the presenting officer has to be appointed.
Yes, okay.
So therefore, that is also a violation. Then
Anything
another-
else?
Another judgment, my lord. Yogeshwar Raham, my lord. Where, my lord? Here, my lord. I just refer to the last paragraph. With regard to my low rank officer, my lord, he is a CFA constable, my lord. Here, my lord, relying upon the Supreme Court's case. This is reported in 1999, 1 GLP, page 76. Yogeshwar Raham versus Menavi. Here also the CFA matter, my lord.
Supreme Court matter?
No, relying upon the Supreme Court, my lord.
Ah,
Supreme Court judgment, my lord. Bhagat case, my lord.
yes.
That also I'll face, Bhagat case also I'll face. Regarding the second round, relying on, in the case of Bhagat Supra, it has been heard to the learned advocate for the petitioner that whenever an inquiry is held against an employee for lower end, he should be offered to give assistance of one other employee of the department who can properly assist him in the matter. But that was not done in the instant case. On this ground, also the procedure failed to violate the authority in conducting the inquiry. So now this also vitiates the law. Now Bhagat case, my lord, is reported, my lord, in 1983 to SCC, my lord, 442.
Yes.
Paragraph 5, I'll read you the page 448. The procedure prescribed for the inquiry was devised with the view to reporting a delinquent employee, delinquent government servant, facing a disciplinary process in residential appointment to 448.
448, yes.
The procedure prescribed for the inquiry was devised with the view to affording a delinquent government servant facing a disciplinary proceeding or residential appointment to defend himself. And by a cabinet decision, it is well established, the delinquent has a right to cross-examine witnesses examined on behalf of the disciplinary department opportunity to lead his own evidence and to present his case of his side of the case. This is the minimum principle of natural justice which must inform a disciplinary procedure. To be precise, the provisions contained in 65 do not make adequate provision for the same. The question is whether it has been substantially complied with. And when we say substantial compliance, we mean that it is too much to presume that a government servant at the level of forest guard to be fully aware of the intricate rules governing the disciplinary proceeding conducted in 1965, containing 1965 rules, and that he must seek permission of proper assistance at a proper stage as completed contemplated with the rules. In fact, justice and fair play demands that when a disciplinary proceeding is the department is represented by a presenting officer, it will be incumbent upon the disciplinary authority by making the appointment of the presenting officer to appear on his behalf, simultaneously inform the delinquent of the fact of appointment on the right of the delinquent to take help of another government servant before the commencement of the inquiry. At any rate, the inquiry officer must inquire from the delinquent officer whether he would like to engage anyone from the department to defend himself. And when the delinquent is a government servant belonging to lower echelons of service, he would be further informed that he is entitled under the relevant rules to seek assistance of another government servant belonging to department to represent him. If this information is conveyed to the delinquent government servant, if he chooses to proceed with the inquiry without obtaining assistance, no one can say there is substantial compliance with the rules. But in the absence of such information being conveyed, if the inquiry proceeds, then it has happened in this case, certainly a vital question will arise To the appellant, Delinquent Government Service servant was afforded reasonable opportunity to defend himself. And if the answer is negative, then negative, the question would be appreciated. But here, as I've shown, there is no question even asked whether he was wants a disciplinary, not whether he wants a deserting, sorry, assistant, defense assistant. And
Yes.
being a low rank employee, he was, he opted in given this opportunity to at least ask this question whether he wants any help or not.
Okay,
That was not that.
all right.
And then 2016-11 SCC director of marketing IOC. Santosh Kumar, this is with regard to the non-application of minor happened in the revision of the 2016-11 SCC 147.
What's the name of the party?
Director Marketing Indian Oil Corporation versus Santosh Kumar. Paragraph 11.
Yes,
A revisional order passed by the appellate party would only within the total non-application of minor appellate party. We have therefore no other option except to set aside the order passed by the disciplinary appellate party. Maybe a matter of what? Fresh disposal of the disciplinary party. Yeah, my lord, was found below the appellate authority that has passed below orders without below any application of mine. And in this particular case, the orders to by the appellate revision authority would cryptic man. They do not go into any of the issues. It's simply they must also apply their mind. Paragraph 9, what is saying, as close scrutiny of.
here you filed an appeal,
FLB.
rejected. Is there a further revisional authority?
Yes. That was-
That was also rejected.
Yes. Both are challenged.
Okay,
And one in this case, Santosh Kumar Singh, there is another CFP matter. There is perhaps at this stage, I don't know whether there are reinstatement that's the reason.
single bench.
Single. 2019 3 JLT number 609. Santosh Kumar Singh versus Union of India. Yes. Thereafter, interface with proceeding. By now, 22 years have gone by, and Inego started something. 22 years have gone by, and Inego inquiry is not visible. Now, since the witnesses are like.
It is confirmed by a division bench order.
Check it out.
It is confirmed by a division bench order.
I'm sorry, I will check.
No, there's nothing to be sorry about. It's confirmed. That's what I said.
Okay.
Yes.
So that there will not be no proceeding was not recommended. So it was directed to be reinstated with some compensation.
Yes.
Well, my humble submission was therefore in this case, the proceedings with not. Conducted in the violation of the rule condition was not followed. And not allowing me not need the help of a defense assistant. Also causing prejudice. I had participated in by started the inquiry with the intention to not cooperate with the matter. And subsequently, this is something which happened which I do with the inquiry. That is the reason I had that's what I explained. And so far as the submission of witnesses etc. are concerned, as I have said, there's one letter they have tried to getting the court, but that letter doesn't show that it was actually communicated. Just whether no supporting document to show that that was communicated. And Lordship is further if you looks in the evidences, I'm not going to read this, but then the indications were that she was continued to become a student. There was no medical examination done. Secondly, my lord, he entered the residence of one Rakesh Rao, who was the principal the officer, the committing officer, and his personal belongings were ransacked, was unsafe. Even his evidence initially what he's saying doesn't implicate the petitioner in such a manner, which later on when the leading questions were asked by the inquiry officer, he elaborates those answers. But others he was taking the name of some other people when entered into his room and said such thing.
You submitted that you rely on a judgment with regard to leading questions.
There are the leading questions he was not discussed. I'm sorry.
Ram Lakhan.
I just Ram Lakhan.
Paragraph.
Ram Lakhan. That is a paragraph number 28. Saying paragraph may be different, numbering will be different. As per the proposition of law is concerned, it's common ground that if the inquiry officer plays the role of prosecutor and cross-examine defense witness or puts leading question to the prosecuting witness, clearly exposing the bias stable in mind. The inquiry.
You're reading from?
So the paragraph 28 maybe. It starts with as per the proposition of law is concerned.
Yes.
It is a common ground that if the inquiry officer plays the role of prosecutor and cross-examine defense witnesses or puts leading questions to the prosecution, which witness clearly exposing a biased state of mind, the inquiry will be opposed to principles of natural justice. Then therefore this honorable court goes on to explain by saying that he can do so in certain circumstances, he can put some questions in certain circumstances, but that will be in the what circumstances putting the questions and to re-clear it. But this cannot be in the form of leading question. It is but the question of the for consideration in this case is whether the inquiry did so. It is also settled law that the inquiry authority is entitled to questions to witness for clarification. Whenever it becomes necessary, so long as the delinquent employee is permitted to cross-examine the witness after the inquiry authority questions the witness. The inquiry proceeding cannot be impeached as unfair. Then, my lord, the summarization of paragraph 32, my lord. Here, 16.3, my lord. He can ask questions for clarifications. The inquiry officer, if they give the right the truth or to obtain clarification, can put questions to the prosecution witness as also defense witness. In the absence of presiding officer, if the inquiry officer puts any question to the prosecution witness to elicit the fact, he should thereafter permit the delinquent employee to cross-examine the witness on those clarifications. If the inquiry officer conducts a regular examination in chief by leading the prosecution witnesses to the prosecution case, or puts leading questions to the departmental witness stagnant with answers, or cross-examines the defense witness or puts aggressive suggestions to establish the prosecution case employee, the inquiry officer acts as a prosecutor, therefore reading the inquiry. Well, here the questions, what we see the questions which are the problem record. The first two witnesses, which was witness was examined, clearly there are leading questions to put. The second witness, my lord, when the questions are put, when he narrated his own facts, my lord, it was not that implicating, my lord. Then he put in questions, my lord, which are leading in nature. Then he came up with certain facts, my lord. Questions are being put, my lord, that this is Rajpal has done this, or Rajpal has done that. Then he was answering. Even the commander.
You'll have to support your statements or submissions that this is indeed a leading question.
Actually, if you actually fix the question, then they have records of the facts of the base, the base record.
No, we are referring to the submissions made by you. You are saying it is a leading question.
Right.
You'll have to support it by saying that yes, these are issues which ought not to have been put in by the inquiry officer, and therefore having done so, it amounts to a leading question.
Well, my basic case of the procedural violation. That's why I didn't go into the tax law, this statements, and I know the lordship is limited very role by examining the witnesses, the evidences in a procedure.
No, that is what we wanted to know. That if the procedure is so rigid,
Right.
that a mere violation of the not putting him the question at the outset itself leads to a violation. Then obviously it doesn't require going into what questions were asked, leading questions, not leading questions, etc.
Judgments of this.
Judgments of this court are not entirely on that. Judgments are of the court that no opportunity was granted to file WS. Presenting officer, yes. Presenting officer has not been appointed, but that is not a violation of, it is not technically violation of Rule 27, because Rule 27 doesn't prescribe.
Well, but then the judgment circle confirm that it is a requirement. Number one. Number two, as the rule 102 again, we calling that. Rule 102 says that wherever it's silent, whenever the CCS rules are coming. The CCS rules will keep the presenting officer. And
No, now the position is clear that yes, presenting officer. But when were this was conducted?
in 1990. In fact, they have to wait the Ramat court, because again send back another thing, whether we refile it, because or lack of jurisdiction, it was never.
But the fact remains, you should have given him some legal assistance.
What can be done? Lordship, can we take his reputation?
No, he fled, but you did not send him a letter saying that you are entitled to a legal assistance, come and participate.
Take his reputation, nowhere is denied the charges that such and such a member of party has not committed such.
He's not denying charges, he's not denying charges, doesn't prove your charges, these are leveled by you.
Lordship, now he's taking all the technical please, that is also not treated in his reputation, nowhere lordship. Only in
Not it.
paragraph 39, he has stated that this violation of rule 27. No specification which particular clause has been violated.
Rule 27, all clauses.
There cannot be made a
Why?
statement, lordship.
Why?
Yes, lordship, yes, to specify.
Why necessarily specified? It is apparent in Rule
We must specify
27.
what prejudice has been caused to him for this violation.
What
There
do
is no
you,
respect to that regard also.
what prejudice? If
That
you
has to be
violate,
stated,
if you-
stated. I will,
if you violate a procedural,
Lordship,
if
I
you
will-
violate a procedure, if you violate a procedure,
Needed and prejudice cause has to be established.
no, if you violate a procedure, that itself presupposes some, that
Lordship, each and every infraction of rules not.
you satisfy that.
Lordship, I
you satisfy.
let him complete, Lordship.
Yes.
No, I.
Yes.
Yes, Lordship. First of all, Lordship, we are all taking all this means that he has not been nowhere created in the reputation, Lordship. the violation of rule 20, presenting officer, then defense assistant, and all that, plea of guilty lodged. Though we have recorded plea of guilty, we put question pleading lodged. That we that on plea of guilty, we have
The plea of guilty, you did not raise at the inception, your rules specify, it must be at the inception.
Yes, Lordship, on 59 we took this question, Lordship. 5999, Lordship. It has been shown in that order, Lordship,
Hmm.
on the record of page. Annexure F, Lordship.
Of,
That I have submitted the to an affidavit of the record, translated copy of the report. It will be page Lordship, 115, that Lordship. The running page.
yes, additional affidavit.
Additional. I was asked to submit the translated copy of the report since the proceeding are in the Lordship. Well, Lordship, just whether you plead guilty or not guilty for the allegation leveled against you.
Page number
Page 115, annexure F.
150.
And the original Hindi version also.
Yes,
Whether you plead guilty or not guilty for the allegation leveled in the ever delinquent members.
no,
also-
when did the DP commence? When did the inquiry, this proceeding?
12/9/99, perhaps the first sitting was held out. 12/9/99.
Where does one find it?
12/9/99, what you will find at page. Hundred and four, Lordship, the question put to him. He was asked, Lordship, so and so, Rajpal, battalion number, so and so, memoranda, annexure 1 to 3, which it was sent to your home address by Commandant 7 Battalion, Jorhat, Assam Pro, registered post on dated so and so, and so and so. Apart from this, copy of the office order, appointment of enquiry was also sent to you on to register. Have you got about letters and orders? His answer was yes, Lordship. Now, at the same address, he received the charge, Lordship. But he received also the rejection of appeal order, but he did not receive the copy of the inquiry report. That has been stated at the dismissal order. Next question, Lordship, all copies of orders commanded in battalion related to departmental investigation, including memorandum charge order regarding appointment of inquiry officer, etc., have been read and make you understand in Hindi language. You understand well which each and every thing written in the above order. Yes, sir. Order which you read and try to make me understand have got well to me. Do you have any objection to the instance? So he said, no, I have no objection. Then Lordship, if we understand all this thing is there, he has been asked whether he received the charge, and we said yes. So here, when his question was put to him whether he guilty, he didn't answer anything, nor he refused to sign the proceeding also, Lordship, of that particular thing. Now, Lordship will go without pleading his, he can elaborate in his rejoinder, but that has to be whispered in the repetition, Lordship. So on this point that presiding of presenting officer was not appointed, there was no defense assistant and all, Lordship. In this regard, Lordship, I would like to rely on a case, Lordship.
What orders were issued regarding departmental inquiry? Is it here?
Professional in the sense, Lordship, the appointment of the inquiry officer. Lordship, paragraph 17 Lordship, of this citation, Lordship. May I just read, Lordship? Regarding the other ground raised by the petitioner.
No, first answer the question that which I put you. Is 104. You said all copies of orders of commandant relating to departmental inquiry. What orders were you, did you send?
Appointment of the inquiry officer, Lordship.
Huh?
Appointment of the inquiry officer.
Appointment of the inquiry. Annexures 1, 2, 3, and 4.
Lordship.
What are these annexures 1, 2,
These
3,
are
and 4?
the statement of allegation and articles of charges.
All right. Now, when was it commenced? When did it commence? The inquiry?
From the recording, that was 12/9/99 was the first sitting Lordship.
Is there some kind of an order sheet that is followed?
This Lordship. Order sheet is there. It's in Hindi Lordship. May I just try to run. आज दिनांकन 12/9/99 को विभागीय जांच अधिकारी द्वारा अभियुक्त नंबर 100 राजपाल तेरे को बल के अपने कार्यालय बुलाया। उसके द्वारा कमांडेंट 100 द्वारा So Lordship, all the daily order sheet was reflected, is recorded and reflected by the inquiry officer. Then the next date is 59, that is on which date the Lordship.
What is that circular which you referred here, 6 of 2005?
Regarding the appointment of presenting officer.
I don't know. It says in supersection of the earlier circular. What was the circular? This is the appointment of presenting
officer.
officer. And defense assistants.
Two 2005, but I have the standing order number 20 of 2001.
All right, you find out, you let us know. Yes, you are referring to the judgment.
Paragraph 17.
Yes,
When the whisper has been made about on any point of it, that cannot be raised to a rejoinder law. Regarding
there is a judgment of the Supreme Court.
there is a Supreme Court judgment also, which has been referred by Justice Amitabh Roy. I have the judgment of it, I have now looked at the copy of it. The next day, by way Supreme Court, that I have been referred.
What was referred?
Supreme Court judgment.
Saying what?
When it can be referred, when it cannot be referred, that in rejoinder, we can elaborate if there is a whisper made in the application and not for the first time in a rejoinder law.
There is another judgment where it says that at any point you can raise it by way of
It has to be dependent on the facts and circumstances.
facts, so it is not a binding
Weight
principle,
balance has to be made.
not a binding principle that you cannot.
Yes, Lord.
The purpose is not to take the other side by surprise.
That is true.
So
Now-
you have been served copies, you have agitated, so to raise
So,
this
Lordship, you
issue.
know where raised what prejudice has been caused in his verification or in his appeal or in the review petition. He has conveniently said that he has lost. Perhaps he is referring those, his appeal and review the petition from the court. Perhaps he has now taken all those ground which are now agitating now before the state court. This basic ground in the writ petition that since he has been acquitted in the by the criminal court or we have been stated. That was his ground in the writ petition. All those infractions no have stated in the writ petition lordship. Except the bail step or statement
What do you say about Rule 27 infraction,
lordship.
mandate or Rule 27?
That has to be specified, which particular has been violated and what prejudice has been caused to the lordship. Merely saying that Rule 27 has been violated will not enough lordship.
It's a procedural rule. The very fact that you, if you don't follow it,
Lordship.
you don't require to satisfy the court that what prejudice has been caused. The very fact that it has been not followed itself is a prejudice.
Yes, lordship. Presidential judgment lordship will be referring on paragraph 28, 29 and 31. Because in the fact, on the point lordship, when a person lordship, he refrains from participating in the will, then we are left with no alternative than to pursue the ex parte lordship. And on the ground of natural justice lordship, it said that it cannot be staged two parts lordship. So there is no straight jacket formula for natural justice lordship. They just read paragraph 28 lordship. The very fact that the petitioner remained unauthorizedly absent from duty for months together itself speaks of his desertion of duty. In such circumstances, there is nothing wrong in declaring him a deserter with consequence and dismissal from service. As has been held by the apex court in so, there is no distinction between admission of fact and admission of guilt. Actually, he has no one denied that he is not guilty of the charges. He has not denied the charges, lordship. Though he has not admitted, but that does not mean he has not denied also lordship. So there is a thin line of distinction between denial and admission lordship. As in the instant case, in that case also the police officer remained absent without leave in prayer. Prayer of extension leave was not granted. Thereafter, charge was framed against him. From the material record, he declared that the petitioner did not take part in the inquiry. It was contended that the inquiry is in breach of principle of natural justice. The effects of noticing that the fact of remaining unauthorizedly absent being an admitted one and that there was no violation of principle of natural justice, it was addressed. Paragraph 29 lordship. In the instant case also the facts speaks for itself. At the first instance, the petitioner deserted his unit without any authority and or leave, and thereafter all throughout remained absent. This being the position, nothing more was required to be established that he is deserted the unit. The violation of principle of natural justice will have to be considered in that context. Business to say that natural justice is not based on any split jacket formula. It cannot be stressed that far in which nothing could be established beyond what has been established without any notice. So even if it lordship all those, the presenting officer would have been appointed, defense assistant would have been given to whether the charges would have been in the different lordship.
Whether
Even if the presenting officer would have been appointed or a defense is given to him, whether the charges would have been different because he has no way denied the charges.
no. Presenting officer is to be appointed because
That is
the inquiry officer performs his duty like a
judge.
arbitrator or a judge. So the presenting officer behaves like a prosecutor. So can a judge decide on the same issue by?
Earlier judgment with lordship, my friend was referring that it will be depend upon it that when he put a question, he should give an alternative opportunity to cross-examine. But here that question does not arise because he did not participate in the inquiry. Now, inquiry officer's job is to unearth the truth, lordship. He has to put question to some, to witness, lordship. That is what he has done, lordship. Lordship, the second citation is lordship, is on 2005 1 GRT page 240.
Yes, which one?
2005 1 GRT page 340. For not really, that's what's its name. I'm referring paragraph number 13 and 14 of it. On procedural practices. The division bench judgment.
Yes,
May I read paragraph 13?
one. Yes. Paragraph,
13 of it.
yes,
As regards to the plea of procedural irregularity committed by the IO in conducting the inquiry, nothing could be pointed out as to how such procedural irregularity allegedly committed by the, even if it is to be correct, cause prejudice to the defense of the petitioner appellant. As noticed above, apart from making some sweeping remarks in the rate petition, nothing has been highlighted as to what were those procedural irregularities, and that is how the defense of the petitioner was prejudiced.
what is the issue here?
Okay.
What are the facts in?
Paragraph 5 of it.
Hmm.
We have heard since then done senior counsel strenuously argued that the departmental inquiry having not been conducted as per the procedure laid down under rule 14 of the CCA rule, the entire proceeding is initiated and non-single judge also have considered this aspect of the matter. He submitted that the petitioner was given reasonable opportunity of hearing and the inquiry is conducted as per the against him. Adding insult to the injury, the petitioner was also not provided with copy of the inquiry report, enabling him to make a representation against the same before imposing the order of penalty. So these were the infraction which he in that petition was to highlight.
This was a, the contentions was, rule 14 was violated.
Right. Yeah, yes.
Here is a question where rule 27 was violated by not putting that question. Or not giving him an opportunity to file.
Petition neither in the appeal and the review petition. Paragraph 49 is paragraph 14 of it.
Of the judgment.
Same judgment of it. The apex court in the case of State Bank of Patiala versus Kisarma has reported in so and so, laid down the law relating to the test of prejudice in departmental inquiry. It was pointed out that an order passed imposing a punishment on an employee contingent upon departmental inquiry in violation of the rules, regulations, statutory provision governing such inquiries should not be set aside automatically, and then the court or tribunal should inquire whether the provision violated is of substantive nature or whether it is a procedural. When a substantive provision has normally to be complied with, violation of any and every procedural provision cannot be said to be automatically issued the inquiry and or order passed. In every case, the test of prejudice will have to be examined and considered in the touchstone of specific trees raised by the inquiry. In that instant case, we find that apart from making some and definite indefinite allegation, the petitioner appellant also failed to show any prejudice caused to his defense by such alleged violation of procedural norms. So lordship in this case, lordship clear a bad statement that has been made in the paragraph 39 of the application. Nowhere is stated what has been violated and what prejudice has been caused. Only in the rejoinder is taken note that no representing officer was appointed and no defense system was given to. That was how I printed in the application. The specific thing of that what has been violated and what prejudice has been caused to you, that is nowhere in the has been stated basically. Next lordship is on the standard of proof lordship, that is 2032 GLP. Page 359. That perhaps is not there.
2013,
2 GLP page 359. The relevant paragraph.
359.
359. Paragraph 13 and 17. also.
Yes. Yes, please. Thirteen paragraph.
70. also. I don't get that copy. It's the problem.
You have it, you read it to us.
Paragraph 13 also.
1-3,
1-3.
yes.
Quoting from the case done this case actually.
This is for the proposition,
Proposition lordship, standard of proof lordship.
standard of proof.
That departmental procedure. Because once raised on then because he has been acquitted in the remaining case, they want to have given the benefit of it.
Yes.
May I just read paragraph 13 of it. It is thus well set in law that strict rules of evidence act and the standards of proof of envisaged therein do not apply to departmental proceeding or domestic family. Which is according to the authorities that place on record all the necessary relevant content and acceptable material fact do not prove strictly in conformity with the evidence act. The material must be genuine and relevant to the facts in issue. Lordship in this case, lordship, that is committed and misconduct lordship that has to be differentiated from the criminal act which he will be performed. He may have been acquitted in that criminal case lordship. In that criminal case, none from the CRPF was examined. Lordship, all three constables of the Assam police and the IO lordship, there has been examined in that case lordship. None from the even the victim lordship, this Rakesh Rao lordship, the commandant was not examined in the criminal case. That's why he has been acquitted, and that was not an acquittal of honorably acquitted lordship. Because of it was not proved beyond reasonable doubt. That's why he has been.
What else is an honorable acquittal?
Honorable is fully established. This is nowhere has been connected with the offence as alleged. Nothing.
So nowhere connected means beyond, not beyond reasonable doubt.
No, not beyond reasonable that must be some at least something.
Beyond, not beyond reasonable doubt itself is honorable. What else is it? You can say, yes, discharge for lack of evidence is not honorable. Acquittal.
Next case lordship is 2004 2 GLT 309. 2004 2 GLT case 309. Union of India versus Shivraj Dev Verma. Lordship in this case, the distance it has been distance has been made while for a lordship in the departmental proceeding lordship. The intention is to maintain discipline in the court lordship. While in the criminal case, it has to be beyond reasonable doubt because being a crime against the society lordship, But in disciplinary proceeding, the intention of the authority is,
Yes, yes, carry on.
the intention of the authority is to maintain discipline in the post lordship.
दोनों काउंसिल से जाने के बाद दोनों का किसको जजमेंट लिखिए और आपको दे देंगे।
Which is with paragraph 25 of it.
2004 2 GLT 309
Division bench judgment of it.
DB
DB,
paragraph
25.
25.
Not it.
Yes.
Well, considering punishment to be awarded to a person by any department or organization, the functioning of the department or the organization concerned has to be borne in mind. The standard of discipline and adherence to the principle of showing rigor and respect to a superior in an armed force or a military paramilitary force cannot be equated with other civilian department. A very high degree of discipline, a deep sense of respect to superior and an abiding instinct to follow the command received are a hallmark of the discipline organization, which is entrusted with the security of the nation. Any leniency or compassion shown in such cases may adversely affect the interest of the force. The very objective with which it is formed and the role which it has to play. Its working ability depends upon a very high degree of discipline and complete disobedience, competence to all just and lawful commands of the superior. Hence, in a force such as the BSF, if the person is allowed to be let off with leniency, even when he assaults his superior in rank, it may become very nigh impossible for such a force to function as a disciplined force. When we consider the sentence or which has been passed against the respondent, we do not find that the penalty of removal from service can be treated as explicit disproportionate or to the gravity of offense or shocking or bias or to this. So, Lordship, the intention of the DP is different and the criminal is different. We have to maintain discipline in the court.
Yes. So you're saying, you're submitting that acquittal in a criminal case does not ipso facto
Lordship.
conclude.
Next is Lordship 99 to GLJ, page 5 to 5. Name of the point is also division bench judgment of
2000.
1999 to GLJ. Page 5 to 5. The party's name was Jitendra Chandra Nath versus Indian of India. Is on Lordship on register post Lordship. And what is the sent on register post Lordship? Paragraph 9, I have relying on it.
Yes.
Because he has raised the question that he has not received that. Paragraph 9, notice the requirement under Rule 21 and 2 was to inform the petitioner and such a sending of the so-called notice under register post will be for sufficient compliance. Further, the address given in the letter was a proper address, and as such, under section 27 of the General Process Act, the service is deemed to be effective. We find no force in the submission that no notice was served. On the contrary, it is well settled that so-called notice was duly served on that one. So in that case, Lordship, then it was the point was that he had not received the so-called notice, that why he could not reply. But here, in this case, also he said that he received the charge memo, he received the dismissal of the appeal order and the rejection of the review order, but he has not received the inquiry report and the dismissal order. So that is very hard to accept, Lordship.
All right.
Next Lordship is 2008 3 GLT, page 812.
What is the name of the party?
I have referred earlier. Did I? I've not referred. Did I refer it earlier? Name of the person is Union of India Mohanlal Das.
Mohanlal is there.
Yeah, no.
Yes.
This decision will also be in respect to registered post lottery. When is written answer? That is in paragraph lottery. When in this case, the notice can answer lottery. So on that point also it will be different.
You're referring to paragraph. You're referring to some paragraph.
Paragraph 26. And it was too much on the part of the petitioner to contend that he did not receive any notice. He deserted from his duty and thereafter remained unauthorized action for months together without any intimation to the officer. In such a situation, the basic authority had no other option than to declare him deserted and to request jurisdiction and police authority to apprehend him. As regards the proceeding initiated against due notice was sent to him in his home address. Thus, it will be seen that all effort were made to trace out the petition. As he had been held by the apex court in so and so, there is a presumption of service of a letter sent by under register power. The burden is but the presumption lies on the party challenging the factum of service. Here, denial is not sufficient to rebut the presumption relating to service of the register letter. In the instant case, there is no manner of doubt that the petitioner acted in an irresponsible manner or unbecoming of the member of the discipline court. He could not have left the place of petition. So, Lordship, see, after each and every person was examined, you send a copy of that deposition to him by register court. Most of the cases, I have annexed some of the articles also in my additional affidavit.
Anything else?
Lordship, on the point of this presenting official option. 2021 PGFT page 261. The division bench judgment of Pramod Malia versus Union of India. Relevant is paragraph 12 of it.
Paragraph
12.
yes.
Be that as it may, the fact remains that no advantage can be given to the appellant writ petitioner on a procedural lapse, which was never challenged by the appellant writ petitioner at the relevant time when the inquiry is going on. In any case, the appellant writ petitioner has not been able to show before this course as to what prejudice has been caused by him by non-presence of a presenting officer during the departmental proceeding. So the prejudice has to be created and established and has to be shown also. Only then you can ask for the benefit of check. Next is the case of 2018 1 SCC, page 231. The name of the purchase is Uttarakhand Transport Corporation
versus Sukhbir Singh, Your Lordship. The relevant paragraph is paragraph 10, Lordship. 9 and 10, Lordship. Can I just read paragraph 10, Lordship?
Yes,
It is clear from the above that mere non-supply of the inquiry report does not automatically warrant the reinstatement of the delinquent entity. It is incumbent upon the delinquent entity to plead and prove that he suffered a serious prejudice due to non-supply of the inquiry report. We have examined the writ petition filed by the respondent and we find no reason regarding any prejudice caused to the respondent by the non-supply of the inquiry report prior to the issue of the supervised notice. The respondent had ample opportunity to submit his version after perusing the report of the inquiry officer. The respondent utilized the opportunity of placing this response to the inquiry report for the discipline of it. The High Court committed an error in allowing the repetition filed by the respondent without examining whether any prejudice was caused to the delinquent employee by the supply of the inquiry report as well with the supervised notice. We are certified that there is no prejudice caused to the respondent by the so Lordship will seriously treat and accept this prejudice. So Lordship, my humble submission is Lordship that although which we are now raising for the rejoinder, there is no whisper, there is no foundation in the first instance trading document, which is the petition. Whatever you taken goes wrong in the appeal and the review petition, you have to have produced the same before this one, but he has conveniently stated that we have lost. Perhaps he has not taken all those ground, that's why he is hiding all those from this. So also this is not a case, and moreover, we have 34 years.
no, this is, this 2018 is on what proposition?
For prejudice, also, he has taken a ground also that inquiry report was not submitted.
So prejudice, that will be, that is, I think ECIL has covered this issue, but nevertheless, he has preferred an appeal.
So in my Lordship, under submission of this is not a case for warrant because yes, in the reasons and other notice is very limited in department of possibility to go into the facts and all. Lordship. We cannot raise disputed question on facts in this issue. In my humble submission, the petition is liable to it.
All right.
Only stand with this, on the point that letters were sent to me and then those were by registered post that they have to be taken as blood, I think we send by one receipt. But they are not next any other postal receipt to show that this registered post letters were to be sent. In fact,
You had answered that you had received all the orders and all this.
no, whatever receipt I will be saying,
Where?
the earlier, whatever I have received, that are already next to me.
No, you have received where?
No, whom, ma'am?
With the address, the same address in which it was sent.
That I'm speaking. What I'm saying is that they have not annexed any postal receipt to show that there is actually postal number one. Number two, the edicas they have used 4 or 5 edicas they have produced before the Lordship of this record. I'm not, this does not contain any of the signature of any of my family member nor myself. And my lord, I do not know, my lord, I'm not very sure, of course, as it appears, my lord, these have got no seal of the postal department, ma'am.
Which the ID card.
The ID cards, ma'am. It might not have come in photocopy, I do not know, that's why I'm saying not very
You
sure.
show it to him. He's the one making allegations.
It may not be there, I don't know. But then, so when the postal receipts are concerned, they are not next a single postal receipts to show that they were actually sent. No, there is no signature at all, no seal at all of the postal department. Not a single seal of the postal department is there. You can write an ID card and give it my file number and saying. This may be one, but other two we have sent, because some letters I have received.
See, the question is, if you have received some letters, you're bound to, there is a presumption that these were served upon you.
No, the question is whether they have sent me. If they have done not, because they have to show the postal receipts to show it was sent.
And another statement in sound, the ID card do not contain any signals in the postal department. ID cards not come like that, but ID card, the postal department, they are similar. Even if it's very served.
Where have you raised these issues?
So therefore, the question of the one letter number will be on the 1610, where the written statement was supposed to have been lot. I was asked lot to submit my written statement within 15 days. That letter will have neither they have produced any ID card nor the postal receipt. So therefore, the contention that I was given 15 days time to file my written statement, that itself is not proved matter. That is not supported by any ID card or no. Can you just write down ID cards and fill the file? It's not a difficult thing to do that. Or you can just write down the ID cards and fill in the file. There's nothing difficult to do that. But if the ID card is.
Did you raise all these issues before the appellate authority?
Appellate will have the appeal copy that's the same, but appeal copy is not.
Where is the appellate appeal copy?
In this record, I have to call it because when you need go on moving lordship.
Huh?
You need goes on moving lordship.
Ah.
Somewhere else, somewhere I have to call.
Is it not connected to the same file? It arises out of these proceedings.
Yes, for the lordship, but you told me that officer who is liaising that in the morning I talked to him. He can, you told me that it can be bought, but it is somewhere in the, maybe where they, you have to find out where the image is. The record goes with the image.
No, where did these records come from?
This is idea of semi lordship.
And in one letter. While he was still in the barrack, while he was stand by his postman.
Or losing you, but he doesn't get the. Inquiry report and that dismissal.
No, this is as per your record. I'm not saying that I received it. You are given a paper, a document. That is dated 1610 at page. Which is when I was in the barrack. And yet you have sent it by registered post. The day before you realize that I absconded or taken with reserve. 16/9/1990, 180, page number 118. He was very much within the barrack.
Yes. Where is the appeal memo? We'll require the appeal memo. What is this time? We have already concluded the hearing. Now you are asking for time. It is for. You are raising this issue. No, he not. He says it is misplaced somewhere. It is not here. Your record should reflect that yes, the appeal does not contain all that. When you call for records, please call for complete records. We are closing the hearing. If you can start it within 2 days, fine. Otherwise, we'll say that it's not available.
I have made this specific statement by repeating that this copies are not.
Yes.
Paragraph 25 and 26.
Yes.
Give closure.
सब्जी जी लिस्ट लाइए ना ना वो कल में देगा कल देगा तुम बोल देंगे ना ठीक हाँ इसका 10 मिनट सब खेलने से काम तेरी नहीं तुमको भी बोलना चाहिए था चक्रवर्ती को चक्रवर्ती को भी बोल दिया ना बोल दिया दोनों को बोल दिया कल में देगा सर को बोल देते हैं ना और सर हम लिस्ट मिलने से हम सीरियल नहीं हो बहुत your duty, you will collect and inform. Never need the well, never need the one. Why not? Come on, police. No, jangan hitam time lagi buat saya. Jadi mau aku tuh kok jangan itu. Tidak, sekarang ini kita tidak ada. Jadi lo mari kita bisa mampu. Kalau kartu mau apa lah? Itu mau. Jadi kita nggak mau. Nah, kartu mau apa? Mari kita itu mau. Mau mau. Kartu mau mati deh. Apa pada itu dia tuh. Di bawah mati sih. Ini bisa apa? Tapi lo sahabat mau itu. Ini tuh pas kita bukan ini jagung sini nomor 70 ini usah kita boleh tuh ini tuh berarti sudah Oh, 7 or 11. Oh, 7 you can then cover. 7 left to down. 11 left to down. Nice. Nice left to down. End कर दिए मीटिंग एंड कर दिए क्या समझे थे हैं इसी बंदा माना है मैं सुन के नहीं करती और कहने सब खेतों निधर डायरेक्ट मीटिंग के एंड कर दिए कंप्यूटर का प्रॉब्लम है कंप्यूटर ने जितना भी प्रॉब्लम है वो फिर बाहर ये आया नहीं ये